Good morning, everybody. Thank you very much for joining in to our event at the Right to a Fair Trial and Measures to ensure the protection of corporate rights. The event is dedicated to the 30th anniversary of the system of commercial arbitration courts of Ukraine. My name is Volodymyr Studunets. I am acting secretary of the Chamber on Corporate Disputes, Corporate Rights and Securities of the Cassation Court of Ukraine within the Supreme Court, and I'm going to moderate today's event. We have the President of the Supreme Court, Valentina Denshevska, with us today, Deputy President of the Supreme Court, Bogdan Lviv, Deputy Head of the Council of Europe Office in Ukraine, Olena Litvinenko, judges of the local commercial courts, academy partners from the EU member states. We also have the judge from Ontario, Canada, with us. Let me give the floor to the President of the Supreme Court, Valentina Denishevska. Good morning. Dear colleagues, dear judges, dear colleagues, partners, and guests, I'm really happy to see you at our first event dedicated to the 30th anniversary of the commercial, in brackets, arbitration courts in Ukraine. I'm sure that today, in front of the computers, we have a lot of judges, my colleagues, who were at the beginning, at the very first stage of establishment of commercial courts. Different sectors were represented in the first wave of the arbitration court or commercial court judges. It's symbolic in a way, because when we all joined the court, I don't think we made really a difference. What's the difference between the work of the state arbitrator and arbitrator within the arbitration court? With the time, we did feel the difference, and that made us real judges. 30 years, that's a lot. That's really a long way that we've covered together. All this time was passed differently by all of us. Some of us with the commercial courts, some joined academia, somebody stayed as a judge and made a career within the court, starting as assistants. You made it to a judge. We are different by age, experience, but one thing we have in common, that's the profession that we have picked up. That's to make sure that there is fairness in commercial relations, and thus we are contributing to the well-being of the country. Development of economy and the development of market economy was developing in line with the development of justice, commercial justice in our country. Sometimes the economy was a couple of steps ahead. Sometimes these were the courts that were ahead, and thus guiding or directing the development so that it matches the modernity. So the significance of commercial courts in Ukraine is harder to be overestimated. Let me congratulate all of us on the 30th anniversary jubilee in a way. Let me thank you for being dedicated to the profession, for your ongoing professional development, for your work. So we still have 2 months before the actual jubilee date comes, but I am sure that we can already start celebrating, thanking each other, talking about the accomplishments and results, and setting new goals. We can start doing this today. I wish all of you to stay healthy, have interesting cases, have grateful students, enjoy your work, and stay the driving force within the commercial system of justice in Ukraine. We'll have several events dedicated to the event. that's going to be dedicated to the protection of the property rights, intellectual property. There will be an event on land issues and bankruptcy. But today, we would like to focus on corporate rights, since without ensuring proper development of these rights and protection of these rights, we can't attract investments, we can't properly develop an economy, free market, and we can't ensure a competitive environment. I'm really happy that today with us we have representatives of the academia, our researchers who developed both the doctrine of the corporate law and case law. I'm happy to see foreign partners at this roundtable. Herman Ziegel, the judge of the High Court Ontario, Christopher Shetler, the dean of the sociological department, University of Heidelberg, Germany. I am happy to welcome Daniel Rittiker, professor, senior lawyer at the Registry of the European Court of Human Rights. And I am happy to see our friend, a colleague. And when you talk about the execution of the judgments, that's the person who guides us through. That's Mr. Pushkar, who is heading the Department on the Execution of the European Court Judgments, the Director General on Human Rights of the European Court of Human Rights. I really appreciate your time. Thank you for being with us. Thank you for your desire to be with us and discuss various issues of corporate rights. Let me also thank our partners who provide ongoing support to the Supreme Court to build its capacity and support us in providing access to fair justice. Council of Europe project for the supportation of Ukraine in respect of Article 6 of the European Human Rights. Olena, thank you very much indeed for being with us and for your support. Ukrainian-Canadian project providing support to the reforming judiciary. I don't see a representative yet, but I'm sure you're with us. A German Cooperation Fund, I spotted Herty on the screen. Very happy to see you. Welcome. And special to the staff of the foundation for the support. Recently, we've seen major changes in corporate and substantive law, and we see a lot of new things appearing. One of them is the new version of the commercial code at the end of 2017. So we changed the category of cases handled by the commercial courts. And one of the major changes in corporate law was the law of Ukraine on LTDs that came into effect in June 2018. The law changed corporate law that is applied to the companies. That's the companies with limited liability. As a result of the legislative changes, especially dramatic changes, we needed to properly interpret them so that they are adequately applied in practice. Therefore, the courts have a leading role in proper implementation of the legislation. Shaping case law as to delineation of the jurisdiction of courts is within the powers of the Grand Chamber of the Supreme Court. And the Grand Chamber accumulated a number of opinions in this regard, and some of them deal with the disputes that arise out of corporate activity in the entities that are in communal ownership. The core issue of judicial protection is adequate remedies that should and can be applied. If a wrong way of protection is chosen, that can lead to really negative results for the climate primarily, since the claimant tends to believe that the rights of the claimant are protected, and if at the execution of the judgment stage, the claimant realizes that the wrong remedy was picked up, that leads to frustration, and that might also lead to the violation of the rights of the third parties. Inadequate remedies, when applied, can lead to the applications to the European Court of Human Rights. In 2020, we have the judgment of the European Court, Safonov versus Ukraine, where the European Court found a violation of paragraph 1 of the protocol and Article 13 of the convention due to the failure of the court to properly register property based on the national decision in favor of the claimant. And that happened due to lack of proper remedy. So the reason for the violation of the convention was the decision of the national court that was made given the improper remedy applied, and thus that led to failure to execute the respective decision. The lawmakers made a huge step forward in development of corporate rights when they introduced the supplementary claim. Thanks to that, the claimant with 10% share of equity can submit the claim in the interest of legal entity and claim damages that were caused to legal entity by the person holding the position. So if minority shareholder believes that management caused damages to the property, the person can file a claim against the manager. So there could be different instances in these cases. For instance, the funds can be siphoned, and whatever decision is made then, that would be insufficient to protect the rights of the shareholder. But justice is the primary task of the judge. So the claim cannot be limited to the damages that are meant to be collected. This claim can also be filed against the third parties that are involved in causing any kind of detrimental effects. So the development of the supplementary claim can be developed further and thus improve legislation. Additionally, it can be also developed through the case law. In particular, for instance, if courts believe that in some specific sector there are some legislative deficiencies or gaps, this can be filled in with the case law. I outlined only some of the issues that are of importance for all of us. There could be a lot more that will be covered by the presentations of our guest speakers, and I'm sure that we are going to have a very interesting discussion today. So I wish all of us interesting discussions, and most importantly, I am sure that this will contribute to the development of commercial case law and judiciary, and commercial courts will set an example for the development of the entire judiciary in our country. Thank you very much, and enjoy the event. Thank you, Madam Vandanishevska. Let me give the floor to Bogdan Lviv, Vice President of the Supreme Court, President of the Commercial Cassation Court within the Supreme Court. Thank you. Good morning, everybody, dear ladies and gentlemen, dear participants of today's event. It's really very difficult to add something to what was said by Madam Danishevska, but I would like just to say that arbitration courts in Ukraine have more than 200 year history since they were set up in the 19th century. And the trends that we see developing in the world when we see the courts on bankruptcy issues being set up, trade courts, financial courts, all the specificities were kind of merged together, and all that led to the establishment of the commercial courts in our case in Ukraine. After October Revolution 1917, there was a period of 5 years when commercial arbitration courts did not exist. It was a very short period of time. But in the Soviet times, with the development of economy, with the revival of economy, new economic policy required more fundamental approaches. And therefore, in 1922, we saw the arbitration commissions set up, and later they were turned into the commercial courts in Ukraine. That was a brief overview of the history that was developing through several centuries, and I'm sure will keep developing and improving. And age would contribute to the quality of the decisions we render. And quality is important, not so much for the judges and for the courts, but for those who seek court protection. With the development of commercial legislation, hopefully will go hand in hand with the international trends in this regard. And our legislation will keep changing from the one that used to be governed by the state and protecting the interests of the state, therefore, will rather take care about the real economy and to protect the rights of entrepreneurs, since that will contribute to the well-being and improving standards of our citizens. That's one of the first events that we are going to have to celebrate 30th anniversary of the commercial courts. But all these events are in a way informal. They are meant to cover the most acute issues that the commercial courts face in applying the legislation and identify solutions to them. And one of the goals is to find solutions that can be practically used. So I am especially grateful to our foreign colleagues that, thanks to the Council of Europe office, participate in this event. And I hope that our practice reflects international approaches. We see legislative amendments in our country. Sometimes there are a lot of them, and that's a good scene, though sometimes we tend to focus on details in laws, which is not always right. The laws should contain the most important strategic ideas and concepts, and then we won't need to change them as often as we do. I wish all of us interesting and useful discussions and application of the knowledge acquired so that it is reflected in the judgments you deliver. Thank you.
за теплі слова. До привітального слова запрошується заступниця голови Офісу Ради Європи в Україні Олена Литвиненко. Будь ласка.
Щиро дякую, пане Володимире. Вельмишановна пані Валентино, вельмишановний пане Богдане, шановні пані та панове судді, учасники і учасниці круглого столу. Мені також надзвичайно приємно і почесно привітати всіх на сьогоднішньому.
Dear ladies and gentlemen, dear President of the Supreme Court, I'm happy to see all of you at the round table that is dedicated.
Ради Європи хотіла б подякувати Валентині Іванівні Данішевській, голові Верховного суду, а також Богдану Юрійовичу Львову, заступнику голови Верховного суду.
Also Bogdan, Deputy Governor of the Cassation Court of the High Commercial Court for their participation and cooperation in the organization of this event. And in general, I'd like to thank the Supreme Court for very effective cooperation with all projects and departments of Council of Europe in connection with the practical implementation of European Convention of Human Rights and Case Law, European Court of Human Rights in the Case Law of Ukrainian courts. Today's event deals with very important part of procedural law. It's Article 6, the right to a fair trial. This is the right that actually proclaims the principle of the rule of law and the importance of the role of judiciary in administration of justice. It's also one of the cornerstones of the Council of Europe. According to Article 1 of the European Convention for Human Rights, all the signatories are expected to organize their legal system in such a way that would allow them to comply with the requirement for fair trial. Consultative Council of Judges, European judges in 2004, talking about the role of judges in the judicial proceedings, explained that Article 6 of European Convention generated the appearance of a number of very important practices in the case law and principles ensuring the right to a fair trial, the right to obtain the judgment within the reasonable term, and also the right to expect proper execution of the judgment. I'd like to say that the Council of Europe's project, which is co-organizer and one of supporters to this event, I'm talking the project about further support to Ukraine in compliance and ensuring compliance with Article 6 of European Convention. This project is now helping Ukraine in ensuring the access to full and effective justice through the execution of judgments of European Court where the violation of this right was found. We are working within the framework of this project with the Supreme Court to ensure strengthening of access, of the right of access to the court, to solve various problems in order to harmonize the Ukrainian case law with the European practices and the rules of case law. Many of the results of this effort will be depicted in presentations of our colleagues, in particular Mr. Pavlo Pushkar, who will participate in discussion to discuss the protection of corporate rights according to European Convention and the Ukrainian legislation. I am pleased to welcome Daniel Ricci here, who is professor and lead lawyer of the Secretariat of European Court, who will speak about the relevance of Article 6 in the context of arbitration proceedings. We believe that today's event creates a unique platform for representatives of judiciary, scholars, researchers, independent experts in human rights to discuss a number of very important matters, international practices and guiding principles established through the case law of European Court of Human Rights. And we expect that this event, as it has already been mentioned, would allow for concentrating around the key problems and challenges that certainly are of common interest. But on the other hand, we will be able to concentrate on effective mechanisms to solve these problems through the implementation of the European Convention of Human Rights. So everything that we will work out today will certainly support or further implementation of the guidelines of Council of Europe and ensuring the right to the fair trial. Once again, my congratulations with your anniversary, with the achievements that Ukraine has had along this path. I wish you fruitful discussion and further successes in your work, while on our side, we're ready to continue all necessary support to the Supreme Court, to the Ukrainian judiciary, with the aim to harmonize the practices with the standards of Council of Europe and European countries. Thank you. Thank you very much for your welcoming remarks. On my side, I'd like to note that indeed during the recent years, Ukraine has made significant steps to improve the corporate legislation, to adapt it more to European legislation and to improve conditions for doing business. And the important role here belongs to the court. And here we need the good quality and predictable judgments. Actually, after we changed, amended the Commercial Code of Ukraine in 2006, which allowed for improving the judicial system in this regard. At the Supreme Court, there is a separate judicial chamber, which actually makes decisions in the relevant area. Also, the Supreme Court is trying to spread and disseminate the positive practices of the courts. We share the legal positions and we publish the number of presentations in the respective websites. Also, we had the special session of Judicial Chamber devoted to the new law on corporate rights of legal entities in Ukraine. We tried to raise the most relevant issues related to corporate disputes both inside Ukraine and beyond. That's why we invited here not only the judges, but also scholars, our partners from European Union and from Canada. So, now we have here about 10 o'clock, so I suggest starting the first session. And I'd like to offer the floor to PhD in legal science, professor of the Department of National Law of National University of Law, Kharkiv, Ms. Fatiyeva. Good morning, esteemed colleagues. I'm really happy to greet all of you. Thank you for the invitation to take part in this event. My thanks to all those who can now hear me. I will be happy to, if my speech is recognized as useful, and certainly we on our side, scholars, have always been trying to actually help dealing with the situations that the cassation commercial court often has to face at the respective chamber of the Supreme Court. Let me launch the conference. So, we can see the screen, I hope.
Так, шановні колеги,
So, dear colleagues, what I wanted to say in my speech, what I'd like to draw your attention to. First of all, I found an interesting quote in order to start with something to share with you some opinions, what the people tend to think about the corporate law. Of course, it's not my quote, but any joke has some elements of truth. So I'd like to draw your attention to what has been stated already here by the leadership of the Supreme Court. First of all, a big deal of attention is paid to the case law. These are empiric approaches. Of course, there is a higher level, analytical level, where to the extent possible, we analyze the documents issued by the Supreme Court, like resolutions of plenary sessions, and we also suggest doctrine. I mean, which are the ways to solve the problems. I'm not going to talk a lot about the corporate law and its importance, although we as academia are used to it in our scientific work. I will not talk about that. Many works have already been written about that, and this is all about understanding of the very essence of these rights. Although the rights, I think, have not still been properly understood. And what is the reason for that? Many works have been written, many summarized opinions have been issued, but still this corporate right notion is not understood quite properly. I think that we are far away from those times when we used to generate science in our offices and only scholars were supposed to deliver any opinions. But I think now it's important to pay attention to the case law, which demonstrates example of the application of the law, and it's time to somehow digest it into maybe share some views and maybe advices, because without that we won't be able to expect any further development in this area. We're all know about the regulatory framework for the corporate rights and corporate relations. Still, we all understand how imperfect these the provisions are, and this can be clearly seen through the case law of the courts. I will try to create a kind of a index rating to identify some key positions that, to my mind, have constituted very effective and possible positive steps towards the resolution of the key problems. And on the other hand, I suggest you anti-rating. That's again my personal view, where I believe there was a lot to be done better, or even these steps were wrong. Talking about this anti-rating, I'd like to say right away that in most of the cases, the reasons were generated by the legislation, because the respective chairman of the Supreme Court is supposed to obey the law. So the positive step was that actually the chamber managed to accumulate all commercial type cases within the same commercial jurisdiction. There used to be many disputes about that. What is the right jurisdiction? Now it's not the point for discussion anymore. Now the important point is that the subject of a sale and purchase deal are not the corporate rights, but the share, the stock So this is what is sold, the stock, the share. And the one who buys the share acquires corporate rights. I'd like to emphasize that because still there are many judgments which mention corporate rights in addition to the words share or stock. Point 3 for me is that we managed to accumulate such notions as the right to a share and the right deriving from the share. It's an old theory. Then I would say that this is an example of the theory which have not changed significantly. It's rather axiomatic. And the problem is that there were cases where the right to a share was separated from the right deriving from the share. Why did that happen? Because there were different procedures to acquire certain rights, and now the case law varies again because to some shortcomings in the legislation. I mentioned that later. But can it be the case that this right to a share and right deriving from a share can exist separately? Is it possible? We know very bright case when one of the married couple is a participant and has the right deriving from the share, and although this one seems to have the right to a share, but still the share is common property of the couple. So we can see two different legal regimes. Point 4, to my mind, it was not a revolutionary approach, but still a very significant step when finally the Supreme Court equalized private enterprises to commercial enterprise, which allowed for resolving many problems because Commercial Code Article 113 identifies the private enterprise in a very unclear way. I personally wrote about 10 articles with regard to this term, but it's still in the code, and the problems are just growing. And the Supreme Court managed to solve that. Point 5 is about the share, about concession of the share, and the court explained what this concession means. It's actually sale or gift. Depending on whether the share has been paid for or not. Point 6 is when any decision of the general meeting is not defined as a legal act. That's the right thing to do, and actually that certainly helped with protection of the rights. So continue the positive rating. In fact, we talked about the right to dividends, and we actually equalized that to an obligation where if these payments are not done properly, then the respective sanctions would apply.
There are several more items. I'm not going to comment on them. That's choose an effective way of protection or remedy. That's item 10 here. Number 11, that a holder cannot be refused in satisfying the claim to find the decision of general meeting invalid just because there were not sufficient number of votes to make this decision. Well, you remember that there were different approaches. There were decisions made by judges when the judge noted obeys the judgment on the small number of shareholders and whether the shareholder attended the meeting or not. It allegedly didn't matter, but it turned out that the right of the shareholder was in free, but the court did not provide effective remedy to protect the right of the shareholders, and this position did matter to protect the rights of shareholders. Here is a separate slide that, from my perspective, seems to be right in the position of the Supreme Court. That's something that deals with the duty to pay interest to the state who is a shareholder in the event when the decision was not made to pay dividends. The Supreme Court pursues a correct approach in this regard, but there is a different position of the Constitutional Court of Ukraine. That's the opinion of 2020, since I'm the member of the Consultative Council of the Constitutional Court, and I provided my opinion in support of the position of the Supreme Court. But at the moment, I would rather not comment on that for apparent reasons, but I stick to the opinion I expressed, that the Supreme Court is right in its opinion. Unfortunately, the Supreme Court can give up on the position, but the Constitutional Court never did that. So if with the time it turns out that it's wrong, then I don't think anything can be done about that. Anti-rating. So one thing I would like to note here, that's changes in the legal stance that's mainly deal with the right, that's the first one, the right of spouse to claim share in the equity capital. The Supreme Court believes that the spouse can claim dividends only, and the Supreme Court has a different role. The Constitutional Court opinion led to the change in the position of the Supreme Court when the share in the equity capital was divided between the spouses. But for a while, the Supreme Court pursued the position that one of the spouses can claim the share in the equity capital. The second, that's companies that are treated as representatives. From practical standpoint, that can be understood, but that's contrary to the civil code under which the rep office, that's legal relations, and legal relations are established between the persons, and persons are separate entities, and these bodies are not bodies. So that's contrary to the civil code, and this established practice of the Supreme Court in this regard, where they stress that the CEO, the director, is a representative, and especially that's important when they exceed the powers. That's Article 17. So it's not something that I can sort of understand. So that's why I included this as an anti-rating. As to the time of acquiring the right to share that was acquired under the contract, it seems to me that it is of primary importance to look at the data from the register. I keep talking about this when it comes to property, when it comes to claiming the right to any property. It's very important to look at data that is entered to the register. Unless you do that, then the register is not going to be of any value, because the data is not going to be kind of, verified there. Number 4, acquiring the right to share as an heir. A few words, there is a lot of confusion here when it comes to legislation. The heritage is really confusing, and that's partly due to the law on limited liability companies, Article 23 in particular. It's a very difficult article to read and interpret and apply. As to contesting contracts of the partnerships, practice is really negative here because the commercial court didn't make the decision how to the person can be expelled from the partnership, because if you expel somebody, then you need to establish an infringement committed by the person. So at the moment, law on limited liability companies does not govern these issues, and the Supreme Court doesn't have any case law on that. 7, that's old cases when the High Commercial Court refused to use analogy. The Supreme Court at the moment is actively referring to the analogy, and that's right, because that's an established mechanism offered by the Civil Code, and you cannot do without the analogy. But earlier in the dispute between Sarmat and Obolon, the Supreme Court noted that the provisions about the prevailing right of the shareholders cannot be applied by analogy because shareholders are not co-owners. So while it seems to me that that's an example that could be included into the list of the anti-rating. So damages caused by the manager of the company, since he was one of the employees, so he's covered about the employment or labor code, and so that affected the liability. It lasted until 2018 when amendments were made. So these are different examples, but anyways, it is clear that there are more of the advantages or positive things rather than negative ones. And these negative phenomena were remedied later. As to the understanding of the corporate law, so it is strange, but the Civil Code doesn't have any definition of that. The worst thing is that recodification concept that was offered to be discussed have a
корпоративні
clear
права
idea where corporate rights are going to be if the commercial code is going to be revoked in particular. I am not going to comment on that, but my question is how and where
не
we have
обійдеш.
to provide for the corporate rights. You can do without that.
Визначення,
Commercial code itself, the definition, the one that we are using for a while, this definition actually has a lot of challenges. That's Article 166, 167, because corporate rights are defined as the rights of person, the share of which is defined in the statutory capital or equity capital, the property of the company. Yeah, so how is it different from the share in the property, if that's joint or co-owned property? How can you make equal the share in the equity capital and the share you can have when it comes just to a property? The law and also the statutory documents should provide for a clear definition of that. that might seem to be an error, but if you look at the interpretation, then you should look at the statutory documents of the limited liability companies and partnerships to seek the correct definition of the corporate rights. So since documents vary depending on the type of company, that might lead to the differences in interpretations. I don't think you should equalize the joint stock companies, limited liabilities companies, because the principles of their business activity are different. Therefore, if the company's activity is based on the contract, then corporates are different there. So corporate relations cannot be equal to contractual relations. These are different relations. Can the persons have contractual and corporate relations at the same time? So I think the answer is negative. So for the future, and I think we had to do that for a while, to clearly define who is the subject of corporate relations, who can be called a corporation. And here we have the definition of corporate relations, Article 167, paragraph 3. What is the added value of this article? From my point of view, there is nothing there, because the article is pretty neutral and doesn't clarify anything. Corporate legal relations are relations that appear changed with respect to corporate rights. So it brings us back to the first paragraph. Who are the parties to these relations? Between whom these relations arise? What's the nature of their relations? You can't just say that these are type of relations that are governed by the commercial code. That's really primitive. We can't say that. What's the legal nature of these relations? It can be differently defined by different scholars or judges. But the fact is that this article doesn't give any definition, even draft definition of what can be legal nature of this type of legal relations. And here we have the procedural code that helps in a way in the understanding. From my perspective, it played a very good, crucial, positive role, since it attempted to deal with this issue and talk about the disputes. And logically, you can say that the dispute arises between the parties to the relations, and therefore we can define the parties to these relations. And here there is a very interesting situation when the procedural code basically defines the subjects, but whether it was done correctly, that's another question. So if you look at the code, who doesn't say between whom the relations crop up, the procedural code says between the entities and their participants. With the respect to the latter, we don't have any objections because we know that the participants or those involved in any partnership do have this type of relations. The same goes for the shareholders. What about the corporate relations between the participants? What kind of relations we have appearing between the participants? And what kind of disputes can appear between them? So you can sort of hypothetically offer the type of relations that can appear, for instance, as to the protection of the prevailing right. But then the claim is filed against the buyer. So if they don't give the consent to leave the partnership again, does it appear there? As to joining the partnership, as to the damages, if we come up with disputes and provide the list of disputes, then you see that they don't appear between the parties. Participants are not parties to the corporate relations. Apparently, the parties to these relations is a legal entity, and those involved in this legal entity where these type of relations appear. But then the participant has corporate rights. On the one hand, if we are talking about corporate rights, then well, corporate comes from the word corporation. So we have a very interesting situation when the legislation corporation is not defined. And we all, whether we are talking about academia, researchers, scholars, etc., when we say corporation, we mean partnership, company. So we have joint stock companies, we have limited liability companies, but commercial code in Article 55 understands company, a commercial organization in a wide meaning and includes state, communal, and other type of enterprises. Can we talk about corporate relations in state-owned and communal type of companies? Why am I saying this? Because in Article 167, we are talking about relations that appear between the participants and a commercial organization. And here we have the controversy. Under the commercial code, corporation is the contractual association of enterprises. Then the civil code doesn't give the definition of corporation at all. All of this speaks about the deficiency of our legislation, and we do need to improve our legislation. Not to take more time, I'm not going to come on the next slide, but the commercial code has the definition of cooperative enterprises, commercial companies, cooperative companies are equal to co-ops, and cooperations and cooperatives are absolutely different companies in all the countries, and you cannot treat them equally. And I think we should take care of that somehow in our legislation. In this slide, I showed this difference between the concepts. These are different legal type of relations that they have. As to bodies of the partnership, I did speak about the controversies here, and a few words about about the objects of corporate relations. I covered subjects already. The challenges here are the following. The share in the equity capital sometimes is defined as 100%. Then can it be equal to the equity capital itself? And then can equity capital be object of the law? Can you sell it? Naturally, no. So we have to remedy that, because there is a mistake there. If I have 2 or 3 minutes, then I can come up with a comment and I'll conclude. 2 minutes for you. Let me attract your attention to some other things that we have with this law. That's Article 23 and 24.
So I'd like to comment on a couple of articles. What is meant by an agreement? Is this a transaction? By whose will it is dictated? How come then general meeting of shareholders is not required? So we just substitute this relation with merely contractual relations when an individual needs consent of all participants to leave a company. If somebody disagrees, then can it be somehow challenged? What if the terms of potential statement to leave were violated. So this article generates so many problems that it really needs some improvements. Talking about the Article 23, I've already criticized it a number of times. Here it's just something like nonsense, because you will never tell who. Actually, if you combine the right to a share, the right deriving from a share, then we say that the heirs inherited shares without any rights deriving from the share, then how it will really can be combined with the laws on heritage. But what if they inherited the shares? Why should they apply for joining a company? And if they fail to apply, then they can be excluded. But who can be excluded? If that's somebody who deceased, you cannot exclude this individual. So how can you really interpret this Article 23? So the legislation clearly creates a number of problems which are supposed to be decided through the case law, and actually this is what the commercial courts have been doing. And thanks to them, most of the problems have been resolved. Thank you for your attention. Thank you, Ina Valentinівна, for very informative presentation, also for your cooperation, not only for the ratings, but also for anti-ratings. And my special thanks for the volume of the literature which is published, where you work as an editor. And now next point is about corporate governance. The floor is offered to Professor of the Legal Department of University of Law, name of the Institute, Mr. Valery Belyanevich. Thank you, Olena Belyanevich. I'm Olena Belyanevich. I'm happy to certainly congratulate you with this event and certainly with our anniversary. I think I've been very lucky through all my professional life. All these 30 years have been devoted to communications with the commercial courts. So I'm very thankful for this opportunity to cooperate with the respective community. I am honored to be part of those who've always supported the idea of commercial jurisdiction. During these 30 years, the commercial courts have demonstrated their importance in establishing the law and order in the economy in a country which is continuously in transition, which certainly is depicted in both the real relationship and the legislation. The courts have participated in putting the things in order in all stages of formation of corporate governance, even during the turbulent period of mass privatization of state-owned enterprises, and later on when the legislation began developing in a more thoughtful and well-established way. And of course, when new laws appeared about these companies with limited liability and additional liability, and when talking here, I will certainly refer to these laws. Talking about the commercial proceedings, the experience always mattered because this is the only way to really reinstate quickly the rights of the businesses. Today, this legal provision is supported by the principle of concentration of the commercial proceedings, including concentration of all commercial disputes within the exclusive jurisdiction of commercial courts. I think as before, as now, the court's practices are not exhausted by merely judicial practices of resolving some disputes. They actually also operate in a very unique way, creating the case law and ensuring, as we've already heard from the Governor of Supreme Court, the reinstatement of justice in economic relations, and in support of this legal commercial law and order, because it's not only about end-to-end relations, but this is quite a complicated, sophisticated system of interrelated relations and links, including corporate governance. Of course, at today's conference, this topic of corporate governance is stated in our agenda is so wide and multifaceted that I chose to mention just separate points which I believe to be conceptually important with regard to corporate governance. These points certainly have a lot to do with the current case law that I try to summarize, and also they have meaning for further development of the case law as additional superstructure in the legislation. I try to apply different approaches, both commercial, legal, and civil legal approaches. We know there are many discussions between our legal schools, and based on the cooperation and interaction, we can find the ways to solve the problems that are faced by both courts and legislators. There are various approaches to corporate governance. You can treat it in narrow meaning as merely activity of a legal entity, or you can treat it as participation of all individuals in the corporate governance. This wide definition was depicted in 2014 in the corporate governance principles that used to define the corporate governance is not limited only by relations between directors and managers. It's not valid anymore, but it used to read that it also includes active interaction with the stakeholders, having weighted activities of the company, like consumers, creditors, and this is because a company cannot exist independently on the society, and the final success of its activity will depend on the contributions made by all the stakeholders. So these principles define the essence of the corporate governance as a system of relations between investors and managers and the stakeholders to ensure efficient activities of the companies and to strike the proper balance of interests. This was a recommendation issued by the National Commission, and I think that it was within the trend of current theories of corporate governance, where the stakeholders are taken into account. I mean, those players that somehow influence where the extent to which the corporation achieves its goals. And these entities are viewed as part of the company, I mean, including clients, suppliers, tax authorities, local communities, and these concepts actually really emphasized the public interest in the activity of a company. So this public interest consists in ensuring the stability, because any conflicts arising in the corporate governance certainly destabilize operation of a company may lead to bankruptcy or any other negative consequences. As of today, these corporate governance principles are not valid anymore. They were substituted by the Corporate Governance Code, approved by the National Commission in 2020. It includes very neutral definition of corporate governance as a system of rules, practices, and processes through which a company achieves its goals. The goals is to create long-term stock value and to generate profits. So the term subjects are used to be used before. Now they are just mentioned several times in the code, but we understand that this code is rather a recommendation. But I think it's a step backwards in understanding of corporate governance. And finally, talking about the case law of commercial courts, they have their understanding of corporate governance as system of relations between participants and bodies of a company in order to implement the corporate rights of all these parties. Thus, the courts managed to classify the types of commercial disputes. Many scientific works were written with this regard, but I think that in some cases this approach has limited potential, especially in the situations where a way to regulate or settle a conflict within a company in connection with the corporate governments cannot be supported through any legislative models. I think these relations indeed are very ramified and complicated, and actually each specific dispute needs to be looked at from its specific context. It's only the only basis where the righteous decision can be made. I think that the to understand corporate governance is to understand the grounds. I mean, the economic power existing in the corporation and corporate property. We know that one of the attributes of a joint stock company and limited liability company is existence of their rights to the property that they own. And actually, the goal of creating a corporation is a way to implement by the founders their right to the private property. So here the owners kind of redistribute the property rights. So on one hand, the right to govern is implemented by the leadership of the company. On the other hand, there are participants who conduct their own activities. And some judgments of the Supreme Court showed that the commercial court indeed are trying to strike the balance between the rights and the interests between the owners and the participants. So one of the judgments was that the powers of governing body cannot be equalized to the rights and interests of its participants. Or another example is that the courts need to keep in mind that the interests of the company may not coincide with the interests of its participants or even former participants. As the result, we are talking now about this corporate property. And it was shown that the shareholders within the framework of the theory are not owners of the corporation. They do not even have any obligations with regard to the corporation. And here what matters is that we cannot see the principle of their own obligations. Another point. the shareholders are deprived of their powers of the owner, but they have other rights like sell a share, vote, the rights to claims, etc. And the third attribute is that the shareholder still keeps his or her control over the capital stock through the system of corporate governance. Then this corporate governance is a system to ensure the shareholders' right through the coordinated activities. Here, the supervisory board and the management board start playing their role. And of course, another aim is to maximize the profitability of the joint stock. So here we deal with the property rights, and we use this very usual term property, but we apply it to quite an unusual object, and we define it as corporate property. What can be deducted from that? Such features of corporate governance as, I will only talk as theoretician, that these are relations of economic commercial order, and the specific subject implements the governance of the corporation and control if such subject has legal grounds and actual capabilities for that. So from the point of view of legal grounds, it was shown that the governing subject is the actual owner of the corporate rights. The minority owner in such situation certainly has the right to govern, to run, but they are deprived of any actual capability to do so. Hence, the legislation needs to provide for special provisions to protect rights of such minoritarian shareholders. So from that, we can think about various remedies. For example, when concluding an agreement, say the procedure provided by the bylaws of the company was broken, and if a share in the joint stock of the company grants the right to make decisions on behalf of the company to such participant, but still because of violation of the procedure when signing the respective documents, this individual would be prevented from any opportunity to run the company. The legislation, on the other hand, just deals with the violation of the rights and interests of the shareholder. Another feature of corporate governance is its principles. I will talk about two major principles. First is subordination of minority to majority. And second, the extent of influence of participants depending on his or her share in the joint stock. Again, it needs to be taken into account when developing respective legal mechanisms and the forms aimed at defending the rights of minority participant, and the fact that this shareholder subordinates or obeys the decisions of the majority is not a violation of the right. So another feature of corporate governance is again about the powers of participants, the power to participate in the governance.
Правомочності, які складає суб'єктивне право.
Specific features of the legal capacity under the law as stated as on the one hand as that's non-property, right? That serves the interests of the party to the partnership. On the other hand, it's different from the owner by its influence. So it's not the overall permit to act at its discretion, as it is done by private owner, but act under the provisions of the law in corporate procedures established by the law and by the laws. The right to participate in the activity of the partnership is closely linked to other property and non-property rights and abilities of the participant, and thus, we see the set of the capacity of the person that are defined as corporate rights. So the concept of the corporate rights is closely linked to the corporate duties, though corporate duties are not used in our legislation. And these ideas are seen differently. Corporate rights are defined as the set of rights and duties that the person found a participant have with respect to a specific legal entity. And naturally, so that's closely linked to corporate responsibility of a person. When it comes to corporate ownership, so the personal duties concept is disappearing. That's the constitutional principle, Article 13 of the Constitution, and that says that the property shouldn't be used to the detriment of the person or society. And at the moment, we don't have any extensive interpretation of the constitutional provision by the Constitutional Court. And we can refer to the opinions that we have. Any 2 minutes, okay. The owner should use the property not only in his interest, but also show respect to the interests of others and society. And in this regard, it seems to me that corporate property binds the persons involved to careful attitude and respect. And here that's linked to the abuses, and there are different researches on that. And the last thing, when it comes to corporate governance, that's a means of protection. Commercial courts and that's expressed by the Grand Chamber opinions. Commercial courts avoid any excessive interference in the activity of the partnership, because that's general meeting decision that should govern that. But if the court refuses to get engaged in the management of the partnership, that wouldn't resolve the well-known issue of 50 by 50, or when the partnership has only several participants. But in case of the hostile relations between them, the general meeting wouldn't be able to make the decision. So the question then is whether the court is trying to distance itself from the de facto conflict between the parties or participants of the partnership, or the court undertakes the function of kind of, resolving and stabilizing the situation between the members of the partnership. So a legal certainty when protecting the rights and the corporate governance per se should be provided for by the quality of the decisions and legislation. But the case law is very important in perhaps through the application of the legal norms, corporate governance norms, and the norms of justice and fairness that are universal for the entire system of law in Ukraine. Thank you again for your attention and congratulations on the wonderful anniversary commercial courts are marking, and let me wish all of us move forward. Let's keep seeking fair and just solutions and decisions. Thank you very much. Thank you for nice words that you said with respect to commercial courts. Thank you for your presentation, and thank you for the cooperation with you. We've enjoyed it for many years. Thank you. The next presentation is methods of protecting the corporate rights. Let me give the floor to Professor, leading expert of the Center of European Studies of the Institute of Law, Taras Shevchenko National University, Irina Kovalenko. Thank you very much. Dear representatives of the commercial courts, let me congratulate you on the anniversary. Let me wish you inspiration in your work and enjoy the respect in your work, the respect that is aimed at establishing of the rule of law in our country. That's a difficult work that you are doing. As a scholar, I have been involved in the commercial courts work for many years. I was a member of the advisory board of the commercial court, and I was involved in improving the law of Ukraine on limited liability companies. And I have always been glad to cooperate and to work with the commercial jurisdiction. When it comes to corporate disputes, let me pick up from the previous speaker who spoke about the challenges the commercial courts face. And for 30 years, commercial courts deal with really complex reality when it comes to disputes, caused primarily with the fact that corporate rights as bourgeoisie phenomenon is characteristic of the United States and European member states. Why? Because the idea of corporate rights, the way we understand it under the commercial code, is not covered by the European legislation or the American legislation. Corporate rights is normally part of the corporation, and corporations in the US are joint stock companies mainly, and the American and European theory stops at here. They don't dwell further on corporate rights, on equity, capital, etc. Ukrainian science borrowed that from our Russian neighbors when we had to govern this institution in the 90s, and we had to fit that and match that against the reality of the Soviet system. So for a while in Ukraine, we tried to govern corporate rights from their own position. And it's only recently when we found solution to that. And when we talk about the selling corporate rights, it's not the way you should speak about it. You should speak about selling the interest or the share in the authorized capital or equity capital rather than selling corporate rights. Getting back to some other issues that we faced in the commercial courts, and they coped with that. That was the issue that I'm going to cover in my presentation, namely methods of protecting corporate rights. Hopefully you can see the presentation. On protection of corporate rights, namely the issues were the following. Legislator narrowly understands the persons that can claim protection of their corporate rights. And Madam Vilanevich said that there is an issue in Ukraine because theory of stakeholders is slowly taken in Ukraine, and it is clearly revealed when we talk about corporate disputes. That's primarily because the protection of the corporate rights is possible only for the members of the partnership. Other persons are deprived of the opportunity to claim protection of their corporate rights. That's mainly due to the nature of partnership, because it's not subject that can submit corporate claim. It's due to some other persons, let's say the persons that are going to become members of the corporation, or the persons that are deemed to be third parties. As to the form of protection of corporate rights, that's linked to the types of protection. Generally speaking, we are going to talk about the protection in courts mainly, but there are some other forms and modalities of protection of corporate rights. In theory, you can single out administrative protection of corporate rights, protection of the rights of the notaries, and alternative. All that provides for the diversity of the protection. That's the term that is very popular in corporate law, and provides to a large extent the effective protection of corporate rights. Courts seem to be the prevailing form to resort to for the protection of the rights, while in the EU member states, that's one of the major but not a dominant one. I'm going to cover the challenges later. The manner of protection was defined by the Supreme Court opinions, and there is a very good definition given there, saying that that's concentrated expression of the content of the state coercion, with the help of which the person whose interests are violated searches the desirable right or interest. So the court can satisfy some claims, but at a later stage, the court might face the situation that the remedy was not efficient and the claim submitted wasn't effective. So that's what the president of the Supreme Court referred to. And recently, the Supreme Court pays a lot of attention to the effective remedies of corporate rights, and that's what I'm going to focus on in my presentation. The Convention on Protection of Human Rights and Fundamental Freedoms, Article 13, states that everybody has the right to effective remedy, and later it was referred to in the judgment mentioned today. That's Safonov and Safonova versus Ukraine. That's linked to the right to co-ownership of apartment and the house. But that's a landmarking case for Ukraine, because it speaks about the effective remedies and state registration in particular. If you talk about purely corporate rights protection, since the time I defended my thesis, and that was 6 years ago, I can say that remedies changed a lot since then. And I can say that some of these remedies didn't become dominant. One of the main forms of protection 10 years ago was finding devalidating the decision of the general meeting decision. It didn't prove effective, especially when it comes to registration. And commercial courts at this stage, given the law of Ukraine on state registration of legal and physical legal entities and physical entities, entrepreneurs, deviated from the position that you should find invalid the decision of a general meeting, and that's one of the most effective means of protection. There are much more effective ones. Here is one of the examples of protection. That's the claim to revoke the minutes of the emergency meeting of the general meeting of the partnership. Sometimes it's very difficult for lawyers to understand why it is a wrong method of protection. Courts may find the decision invalid rather than minutes of the general meeting. As to this method of protection, I can say that if you are governed by the principle of the rule of law, the Supreme Court delivered an opinion whereby the claim on revoking the minutes of the emergency general meeting was equal to the revoking the decision of the general meeting. And revoking the decision of the general meeting is the method that is not often used internationally. Typically it would be the derivative claim or damages. In Germany, finding the decision of general meeting invalid is a popular method of protecting corporate rights. So if you look at the theory, you can hardly find one method that would be the most effective for all corporations. You need to base that on the reality of a specific country. Getting back to the law of Ukraine on state registration of legal entities and physical persons, entrepreneurs, and civil associations, I can say that the law provides for effective methods of protection when defining the equity capital amount and the shares there. And that's the decision that speaks about the equity capital, and the judgment that came into effect that deals with the partnership. And as of today, we have large case law developed on that, and the Grand Chamber of the Supreme Court delivered an opinion where it provides the exhaustive list of methods of protection for the Ltd companies that is part and covered by Article 17 of the law of Ukraine on state registration. So the persons that are trying to find invalid either the decision of the general meeting or the statute, they choose then the ineffective method of protection because it's not governed by the respective law of Ukraine.
стейкхолдерів і про третіх осіб.
I would also say a few words about stakeholders and other parties that I discussed before. You see at the very beginning, the creditor, in that case, wanted to submit a claim with the purpose to cancel the registration of the proceedings in the single register of criminal proceedings. But the courts decided that that's not the proper remedy, just because the creditor cannot be a plaintiff in this case. I wouldn't go to analysis of specific cases, but I'd like to give it as an example of the fact that the remedy really depends on the individual claimant. Talking about an efficient remedy, I mentioned here 3 examples. They are quite popular from the point of view of protection of the rights. When actually the clients are trying even to impose this approach to the defense lawyers to protect their rights, although that's the wrong remedy. First is that the court cannot function for participants of a company. It cannot redistribute their contributions or change their decisions. It's the wrong remedy. Another point is that the suspension of validity of the laws is the wrong way to defend the rights. And the third point is that the legislation does not provide for protection of the rights and legal interest of a commercial company through declaring invalid its decision. That's because only participants of such a company may file such a claim. So again, that's important for purposes of choosing the right remedy. The court judgment needs to be effective tool to reinstate the violated rights, and here a very positive aspect is that the judgments of commercial courts of different level often use the word effectiveness, and again, it's very important. Talking about some positive developments in commercial courts during the recent time, I'd like to mention the fact that the audit was recognized as a corporate right, and one of the remedies was defined as the right to demand an audit. Before that, there had been a number of problems with satisfying such claims, but in some cases, an audit can really be a way out of the situation, because this is a way to check the real financial condition of an enterprise. Now the commercial courts deem it a proper remedy, and it's a positive phenomenon. Yes, I'm about to finish. Also, I'd like to know some alternative forms to mention their importance. First is the mediation. We've heard a lot about that recently. It's kind of a nice way to protect the rights, but the key point is that's the effective and very efficient remedy in many European countries. In the United States, more than 50% of corporate disputes in the US and EU are resolved through the mediation. But mediation is not just a word to introduce in Ukraine. The Ukrainian legislation needs to be changed. In particular, I'm talking about a specific alternative of European Parliament about some aspects of mediation in civil and commercial disputes. It allows for declaring a decision made through mediation binding for the parties. Had we had these tools, of course, companies would have had alternative ways to protect their rights. Because we have many problems with these methods of protection. The entities that are allowed to enter into commercial dispute, they wouldn't play much of the role here. And as far as the arbitration is concerned, yes, some types of commercial disputes may be considered this way. In some cases, it's even possible in Ukraine, but the problem is that in Ukraine, the bylaws, by statute, is not a contract, while in the United States statute or bylaws is a contract, and thus these parties may claim the violation of their contractual rights through the arbitration. In Ukraine, it's not possible as of now because of very famous Article 22 of Code of Procedure, where a number of issues related to corporate rights, in particular, the point about corporate rights prevents individuals from filing claims with the International Commercial Arbitration Court. I want to thank you once again for your attention, for this opportunity to speak. Yes, we are very thankful to you for your very informative presentation, for your very nice words about the courts. So we are done with session number 1. According to agenda, we have 10 minutes break. I suggest that we move forward with the next session. And I would offer the floor to the Justice of Grand Chamber of Supreme Court, Mr. Tkachuk, please. The floor is yours, Mr. Igor Tkach. Thank you very much for the floor. Good afternoon. I thought we would still have a break, so I'm sorry it will take a bit to download the presentation. You see, the next speaker, Mr. Pushkar, requested not to delay because he's supposed to be at another event. That's why we thought we would take advantage. So then tell me, how much time do I have in order not to create delays for Mr. Pushkar? Yeah, you're right. So 11:20, 11:40. It's okay. So good afternoon. I'm happy to greet all participants of this event. Can you see my presentation? Yes, we can see it all. Thank you. Everything is great. So the subject matter of my presentation is on matters of jurisdiction of corporate disputes. And to continue a discussion of the aspects that have already been mentioned by our esteemed scholars, I'd like to note, first of all, that the issues of jurisdictions are also related to the problems and developments that are included into scientific doctrine. And when reviewing the disputes, we often refer to academia, and we use their conclusions and opinions when considering cases about the rights, corporate rights in particular. When we talk about matters of jurisdiction, first of all, of course, Grand Chamber of Supreme Court proceeds from the principle that criteria of defining jurisdiction need to be simple and clear. So this is the basis of the case law of our grand chamber, and it's actually a guarantee of the correct and fair consideration of a dispute, and that's our goal. I'd like to note that, of course, there are some problems, but most of them are related to legislative regulation of the matters related to jurisdiction. In particular, definition of corporate rights, corporate relations. So these problems do exist. Case law allowing for separating the cases subject to consideration by commercial jurisdiction. Point 1, Article 6 of European Convention. There is that everyone has the right to a fair trial in the court established by the law, which is supposed to define the individual's rights and obligations. The latest development in Ukraine do allow for meeting, for saying that we do comply with the notion of the court established by the law, which is supposed to consider cases within such court's competence on the basis of the principle of the rule of law. On the other hand, the matter of jurisdiction of judicial disputes, including corporate, is still important and is still in place. And I need to note that the European Court for Human Rights delivered a number of judgments where European Court stated that to ensure proper and effective access to justice, there should be a possibility to challenge any actions constituting interference with individual's rights. I mean, an individual must have an opportunity to file a claim with the court established by the law. Judicial jurisdiction is an institution of the law aimed at separating different jurisdictions and different types of administration of justice, civil, criminal, etc. So the separation or delimitation of jurisdictions often constitutes grounds for dispute, depending on the type of administration of justice where the cases will be considered. I need to say that the category that we are discussing is clearly defined in the law on procedure, in particular in the Article 120 of Commercial Code of Ukraine. And I'd like to note that the trend is that the jurisdiction of commercial disputes is defined, well, in contrast to what it used to be before, depended on the actual parties or subjects, claimants and defendant. That in 1992-91, the versions of the code defined that legal entities may be parties to commercial proceedings. Later on, other entities, including individual interpreters, obtained the opportunity to address the courts, and today both legal entities and natural persons, entrepreneurs, and even those who are not engaged in business may be participants in the disputes considered by the commercial courts. So in these aspects, it's very important to make sure that any corporate disputes where the natural persons may participate as founders of legal entities, all these disputes still are subject to review by the commercial jurisdiction courts. This is a very positive achievement because Before, all these disputes were really fragmented around various jurisdictions, depending on the specific parties, and even the same dispute could be considered in parallel by administrative, commercial, and civil jurisdiction. Certainly, all that led to very significant fragmentation, and actually deprived individuals of possibility to have effective protection of their rights. As of today, legislators define the categories of disputes subject to consideration by commercial jurisdiction. Again, that's Article 20 of the Code of Commercial Procedure, items 3, 4, 5, and the only problem we are facing is to delimitate, to separate these disputes from the disputes subject to consideration by civil and administrative jurisdiction. The categories that you can see on the slide subject to review by commercial court: a novelty is a dispute between legal entity and an official for compensation of damages caused by the actions of the official.
Якісь питання, що стосуються юрисдикції, тому
In this area, the jurisdiction is really disputed and challenged. So we'll talk about the other two categories where such disputes are more typical. Talking about procedural peculiarities of consideration of corporate disputes, all can be reduced to just very quick definition that corporate disputes are considered exclusively by commercial courts. They cannot be referred to tertiary court or any international arbitration. And the law procedure establishes special requirements for filing a claim within the corporate dispute framework. What are the criteria that need to be taken into account to define a dispute as a corporate dispute? I really apologize, I'm sorry. So I'm really sorry. So just to continue, talking about criteria that need to be taken into consideration when we define a dispute as a corporate dispute. First of all, it's subject matter of the dispute and the nature of disputed legal relations. In each specific case, we should proceed from the essence of this right of or interest, which needs is to be protected by an individual. So which specific rights have been violated? Claimant's rights, and whether these rights can be subject to consideration by commercial jurisdiction. That's the basic and the main question. Talking about parties to the legal relations, here the general rule is that this is about the disputes between the parties who are participants or founders of a legal entity and have the right to govern this entity.
At the same time, under the established case law of the Grand Chamber of the Supreme Court, corporate disputes are also disputes that are to do with the establishment, management, or termination of the activity of a legal entity as some type of an organization between the members of which there is some kind of legal relations, whether between them as persons or as persons and legal entities. So previously, the position was limiting corporate relations as the relations between the partnerships, whether that's LTDs or joint stock companies. But today, case law and the position of the Grand Chamber of the Supreme Court has been changed, and the transformation is caused inter alia with the by the changes that we saw in the legislation, namely the paragraph 3, Article 20 of the Commercial Procedural Code of Ukraine, where the definition of the disputes is given. So we need to look specifically at the dispute that arises from corporate relations. And depending on that, we determine the jurisdiction of the court to handle the case in question. Challenges of disputes as corporate ones. Here is the group of disputes that deals with revoking registration of or any registration actions of legal entity that became a typical group of cases or revoking the registration is to be done under commercial procedure. Previously, they could have been handled by administrative courts and commercial courts, but the Grand Chamber is consistent in its position, whereby if the dispute is the dispute about law, so that's the dispute that is to be decided by commercial courts. In one of the cases of the Grand Chamber, the claimant went to the commercial court. It was the case against state registrator, but the Grand Chamber there established that the dispute de facto was to do with the exclusion of the claimant from the membership of the limited liability company. So the Grand Chamber concluded that this dispute is private, since it deals with private rights of a member, and actions to revoke registration could be deemed as derivative in this case, and they have to be decided in one proceedings where the commercial court hears the case on the merits. So thus the court dealt with one other scene where one dispute should be heard in one proceeding. So when the person goes to court, so the claim should be worded in the manner for the dispute to be decided in the court of proper jurisdiction with adequate remedy of protection. The person that went to court seeking protection his her rights and interests. Grand Chamber of the Supreme Court with respect to Article 4 that's the competence of the commercial courts that should handle disputes on contracts that deal with shares, interests, and other corporate rights of legal entities. Is as follows. They are singled out from family disputes and heritage, but when it comes to family relations, that's the relations between spouses, and if legal relations go beyond this type of family relations, then the chamber sees them as the cases that deal with the interests and shares, and thus they have to be handled by the commercial court or commercial jurisdiction. Article 20, paragraph 3 of the commercial procedural code of Ukraine deal with the or linked with the Article 166 of the Commercial Code that give the definition of corporate rights and corporate relations. But we have to be guided by the procedural legislation primarily that define jurisdiction. That's Article 20, paragraph 1, part 3 of the Commercial Procedural Code of Ukraine. And here we see some changes that have been caused by the fact that the Commercial Procedural Code of Ukraine, the previous version, that's Article 12 of the CPC, and currently that's Article 20, starting March 28, 2014, we see the new version of the legislation whereby corporate relations, their scope were expanded. Previously, it was stated that the disputes that arise from corporate relations were the relations between the company, its members and founders. But following the amendments to the CPC, instead of the commercial partnership, we have legal entity, and founders, members, and shareholders were added by members of legal entity. So that allows to expand the scope of application of corporate relations, and Grand Chamber, when handling cases, interprets it in a broader meaning. So corporate relations are seen not only as relations inside the joint company or the limited liability company, but corporate relations also include inter alia relations that we see in cooperatives and other non-commercial organizations as well. For lack of time, I'm not going to cover in detail this issue, though it is a challenging thing, and it is subject to intense discussions. Here is briefly the case law of the Grand Chamber on this issue. That's disputes with respect to cooperatives. The opinion of the Grand Chamber here is that the disputes between legal entities that are not commercial companies, co-ops, farmers, cooperative enterprises, and its members, de facto we have corporate legal relations, and in this case the Grand Chamber found that members of the cooperative, irrespective of the type of activity, are bearers of corporate rights. So corporate relations as defined by Article 20 of the Commercial Procedure Code that we have effective today. The same with the involvement of the small company, the bar association. There was a case handled by the Grand Chamber. The dispute dealt with the expulsion of the counsel from the bar, and having assessed the circumstances of the case, the Grand Chamber concluded that the dispute dealt with membership of the council in the association of the lawyers. So this dispute should be handled by the commercial jurisdiction court. And to conclude, a few words, the disputes on terminating the powers of officials. That's another interesting issue. We are talking about terminating the powers of the managers of enterprises, and we have some legislative changes in that regard. Paragraph 3, Article 99 of the Civil Code of Ukraine was amended, and the owner or shareholder can terminate powers of the officials at any moment without explaining the reasons for that. The officials, meaning executives. So the compensation for the period of 6 months is to be rewarded, and other damages or compensations can be specified on a case-by-case basis. So the question here is, what would be the jurisdiction to hear these disputes if the executive whose powers were terminated goes to court? The Grand Chamber concluded, and that's reaffirmed by the resolutions of the Supreme Court, that this is commercial jurisdiction courts that should handle this type of disputes. The reasoning behind that is as follows. Legislation, procedural legislation, whereby the scope of corporate disputes is expanded irrespective of the subject composition. That's the first. Secondly, this type of relations are the ones that deal with the corporation. So the manager's powers could not have been terminated. The powers of the manager could not have been terminated by the owner, irrespective of the fact that he lost credibility. So we are switching over to the compensatory type of remedies, and these type of disputes should be handled by the commercial courts. That's the position of the Grand Chamber as of today. So I think that's it on my part. Naturally, all these issues that deal with jurisdiction need to be further developed and improved in laws and by case law. Thank you, and wish you interesting discussions. Thank you for having found time for this presentation. Thank you. Protection of corporate rights under the European Convention on Human Rights, the genesis of the case law of the European Court of Human Rights, and the execution of judgments in cases concerning Ukraine. The floor is given to Pavlo Pushkar, head of the division of the Department for the Execution of Judgments of the European Court of Human Rights, of the Director General for Human Rights and the Rule of Law of the Council of Europe. Over to you. Good afternoon. Thank you for the invitation. Let me congratulate all of you on the 30th anniversary of establishing the system of the commercial arbitration courts. And this event is specifically dedicated to the 30th anniversary. I'm very happy to see and welcome all participants on behalf of the Director General for the Human Rights and Rule of Law and the Department for the Execution of the Judgments of the European Court. I tried to prepare some kind of presentation for today's discussion. The time is of an issue. We had just finished the meeting of the Committee of Ministers of the Council of Europe on the execution of the European Court judgments, where Ukraine's cases were heard as well. A notorious Burmich case that deals with the non-execution of the judgments and access to justice and generally enjoyment of the rule of law principle. I'm going to talk about all that in my presentation. So here is the focus of my presentation. Today, I would like to speak on several things. Firstly, to speak a little bit more about the protection of corporate rights in the European Court, given the applications filed to the European Court on this issue, and the judgments of the European Court that deal with the execution and the one that are under the supervision of the Committee of Ministers of the Council of Europe. So we have 560 judgments of the European Court under the supervision of the Committee of Ministers of the Council of Europe. That's out of more than 1,600 of the judgments delivered by the European Court against Ukraine. Ukraine remains among the top out of the countries in terms of the judgments delivered and supervised by the Committee of Ministers, and by the number of the applications filed to the European Court. Ukraine actually ranks third in terms of the applications. Most of the judgments and proceedings that are currently sitting at the European Court and supervised by the Committee of Ministers deal with structural issues. So you can single out 6 or 10 of them that deal with the judiciary, impartiality of courts and judges, functioning and efficiency of the judiciary in the country, namely excessive length of proceedings. To a lesser extent, that's typical of the commercial courts. They are pretty effective, but at the same time, partly that's to do with them as well. That also deals with the issue of non-execution of decisions or judgments and access to courts as well. The cases as to the protection of the rights of legal entities and economic rights remain the key ones at the European Court. And with respect to Ukraine, I would say that situation was really non-typical, because at the initial stages, and I remember the first events we had with the Supreme Court back in 1999 and the year 2000, when we saw the first judgments delivered. It was the case of soft roads after, and the then agent of the government before the European Court raised the question why European Court of Human Rights is focused not on the protection of human rights, but the protection of legal entities instead. So in other words, whether legal entity can be a bearer of human rights given its legal and formal status. And this question was pretty clear given the case law of the European Court and given the Convention Article 34, namely, who specify who can go to the European Court for the protection, as well as Article 1, Protocol 1, that clearly established that it is legal entities, similar to physical entities, that can go to European Court for the protection of their rights, namely to peaceful enjoyment of property, Article 1, Protocol 1. And the first judgments against Ukraine were the judgments that dealt with the operational work of the commercial courts and protection of corporate rights. And here I recall November 1, 1998, when the former European Commission on Human Rights and European Court of Human Rights were merged into the European Court of Human Rights. And at this meeting on November 1, 1998 in Strasbourg, we had the president of the Supreme Court, the head of the Constitutional Court, the head of the Arbitration Court of Ukraine, and they did talk about the self-TransAuto case, why it became the landmarking case, one of the pioneers, if you wish, that dealt with the system of the commercial courts per se, and with the courts in Ukraine or their impartiality and administration of justice in particular. Why was it the case? The main reasons for that are as follows. You can say that the quality of legal protection of the legal entities' rights was at much higher level versus the way the
осіб, тобто потужність тих юридичних фірм.
So we are talking about the quality of how the defense was performing their functions, and actually when the files were submitted to the European Court, this quality increased. And I can share my personal experience of work with the Secretariat of European Court for Human Rights for more than 16 years, and I can tell you that the quality of submissions and actually quality of judgment delivered by commercial court was really different from the quality of judgments delivered within the system of common courts. I would certainly emphasize here criminal proceedings where the level of ground in the judgments was quite high, and one could see very big difference in some categories of cases. I mean, the way actually the judgments were written, and thus self-TransAuto became one of the first cases where the European Court delivered judgments. So I would mention some of the proceedings in view of a lack of time. So I'd like to draw your attention to the case Ukraine versus Tyumeny, which talked about taking the corporate veil off the relations between the state that was the shareholder of this legal entity, joint legal entity with the Tyumeny Oblast of the Russian Federation, where the statutory capital was actually transferred to a location in the city with a specific address, and then this money was actually withdrawn from the statutory capital, and thus this company then was deprived of its property. Similar to self-TransAuto case, the court found violation of Article 6. I'll talk about it later. In this context, I would also mention an important case Lugansk Vugilya joint stock company. Again, it was, first of all, the decision on admissibility. And again, the case was about the shares of the equity, the rights of the shareholders from the point of view of whether it's possible that state-owned joint stock company can file claims against a specific individual, and then the court concluded that such entity cannot really sue the state because it's the institution fully owned and controlled by the state. Although in part the court agreed that it was performing some separate functions within the sector of its activity, but it was quite an interesting judgment from the point of view of limits of state liability and Article 34 of European Convention of Human Rights. I need to say that the interesting side of those judgments, and here I'd like to also mention the letter of High Commercial Court concerning jurisdiction of European Court of Human Rights, which was drafted, I believe, sometime in 2008 or 9. And they mentioned a segment of Article 41 of European Convention from the point of view of the right to compensation for legal entities. There is some interesting case law of European Court when it was a judgment against Portugal, stating that legal entities also are entitled to compensation of moral damages. This same case was supported in the judgment Regent Company versus Ukraine. It was again about the interaction between the commercial courts and arbitration courts, where the disputes between private shareholders were settled, and in particular, companies buying out the debts
Тільки не зазнають такої
didn't have the right for compensation of moral damages because due to parameters of their activity. Also, I'd like to mention several points about execution of these judgments. I'd like to say that the judgment in the case of Transavto has already been closed, and the execution proceedings were finished also in 2019, but execution of judgments in the group of cases Ukraine too many, it's about expropriation of property without paying out compensation to legal entities, cancellation of judgments with the violation of principle of legal certainty, a violation of the right to fair trial, and the problem with the impartiality of the courts. These issues are still under review of the Committee of Ministers of Council of Europe. They're still monitoring that situation, and during our supervisory activity, we will have to check to what extent the legislation and case law of national courts have managed to deliver proper solutions of these problems. Also, I'd like to note that some of the segments mentioned today concerning the execution of judgments of European Court are also monitored under control, together with the case Svetlana Naumenko. And also there is a number of cases related to judgments delivered by commercial court and moratoria declared by the states. And again, that's in connection with Ivanov and Burmich, where the execution proceedings are there for probably 20 years and have not been finished yet. Talking about the right to enjoy peaceful enjoyment of the property, it's still the key segments of the activities of both European Court of Human Rights and the Committee of Ministers of the Council of Europe, exactly within the segment of protection of efficiency of such remedy according to Article 1 to Protocol 1, the right to peacefully enjoy the property. And I'd like to say that the situation concerning the protection of the rights of legal entities and protection of corporate rights still presents many problems. But if we refer to Transavto and Ukraine too many, these cases are different from the point of view of ensuring legal certainty. And now it's not about systemic violations, but several cases where legal certainty principle was not complied with when deciding on compensation. Such cases are now under review of European Court for Human Rights, as well as some other cases that will be discussed today. Similar cases discussed by my colleague, Professor Richter, of the European Secretariat of European Court for Human Rights, and he will talk about correlations between state courts and the arbitration courts when dealing with the protection of the corporate rights. Thank you for your attention. I apologize for not being able to stay with you any longer. Unfortunately, I have some other obligations that actually force me to leave this event. I will be very happy to receive any of your questions. I'd like to leave here my email address, and if you have any questions or you need any additional materials or information, we will always be happy to share some materials and information to help you with the better familiarization with the judgments delivered by the European Court and Cabinet of Ministers. Thank you very much for taking part in our event and for your very informative presentation. Thank you. Notions and criteria of corporate dispute. The word is given to Alexander Kolhoda, Professor of Law of Institute of Law of Kyiv National University, Taras Shevchenko. Good afternoon, colleagues. First of all, my congratulations with the 30th anniversary of establishment of commercial court system. My wishes to you is to protect the independence of your courts in spite of all attempts to reform the judicial system, because the commercial jurisdiction, no matter how close its proceedings are to other jurisdictions, certainly can be characterized as a jurisdiction that really helps with resolution of very important series of disputes. Talking about criteria for corporate dispute, here I would say that in spite of very theoretical maybe name of my presentation, we could see already here that normally the issue of jurisdiction, in spite of any well-established terminology, there are doubts and disputes about the jurisdiction. This notion has no definition in the legislation. There is no single approach to how to define this term, and some terminology used in the legislation actually generate these issues of what we should define as corporate dispute, corporate relations. I will start with the definitions and meanings that we use in scientific research. Corporate disputes are those that are between the participants of corporate relations, I mean, related to any governance of a corporation with regard to corporate rights as provided by the law. That may be disputes concerning any suspension of corporate rights and interest or proper distribution of the property owned by the corporation. But that's not necessarily the subject matter of all corporate disputes. It may be, actually, it may deal with the violation of the corporate law. Corporate dispute as a dispute between the participants, including shareholders, if or for instance, a participant who challenges any decisions made while he or she was a participant, or maybe any decisions to seize specific relations like labor relations. Supreme Court delivered number of determinations, including Grand Chamber's determination, where they used the criteria with the referral to parties of the dispute, and where they paid special attention to the parties to the dispute, meaning the participant and the legal entity of corporate type. Another determination is mentioned here on the slide, and they pay attention to the fact that such disputes are related to corporate rights. The corporates concerning protection of corporate rights by their bearers. I mean, those who are participants. Talking about the Commercial Code of Procedure, indeed, the disputes arising from corporate relations, it's a synonym of a corporate dispute. This regard, the theory is based on item 3 of Article 10, but at the same time, there are other categories of disputes that may be corporate if a party grounds his or her claims on the fact of violation of his or her corporate right. Another category is so-called derivative claim. This is a claim on compensating the damages caused by a corporate entity. I agree with Lena, who stated that definition or declaration of a dispute a corporate will depend on the very notion of corporate relations, participants of the disputes, the specific parties having a conflict, and also the content of the conflict, and whether it's possible to resolve or settle such a conflict within the framework of single proceedings. In view of that, we can separate several criteria for corporate dispute, meaning the content, the nature, the character of disputed relations, grounds for claims, violations, non-recognition of a corporate right or the interest. In most of the cases, we're talking about violation of corporate rights, but respectively non-recognition of such rights may also constitute grounds for a claim. And other protected notion is the interest, which also can be subject to protection, subjects or parties to the dispute. I think that legislators actually expanded in the Article 20 the list of such parties, and we created the problem because legal entities may be quite different, and I'm talking about a legal entity as a kind of a fiction which prevents us from defining a specific organization. So we're talking about commercial organization of corporate type and participants of such organizations. The subject matter of the claim may include various demands, including use of special remedies or declaring invalid of some decisions of the corporate government bodies. So first of all, we need to identify what are corporate relations. They are relations that arise, change, and disappear with regard to corporate rights, as the code reads, but I support the opinion of academia. Some of them already expressed their opinions here, and actually they draw attention to the fact that such relations may arise with regard to corporate governance. they may arise and disappear at the stage of formation of a corporation. And since now often the governing body is recognized as a separate body of internal corporate relations, it is recognized that it is possible. But when we are talking about corporate disputes, we need to have an entity and a subject who takes part in this dispute. So it should be a legal entity rather than its governing body. Talking about Article 167 that has been criticized already, I'd like to draw attention that it mentions a commercial entity, but unfortunately without saying that this is corporate organization. So the state, the legislation does not provide for clear definition of what they are. This slide shows my attempt to share you some features meeting the corporate type that could be then used in order to define whether a specific organization used by this entity is a corporate organization.
Mainly, you need to pay attention to these criteria when looking at the founding documents of the company in question. Parties to corporate disputes out of corporate type of organizations could be organizations that are established as partnerships. We know that it is a widely used form for the companies, not only by 5 types of partnerships, but also by banks and non-banking financial institutions, corporate investment funds, pension funds, clearing institutions, etc. So apart from the corporate type of organizations, we have private companies that are established based on the property of 2 or more persons, farmers and cooperatives. Additionally, these organizations should also include companies' unions, the associations of lawyers, the bar, the associations of consumers, and some type of civil type of unions and associations and organizations. Having analyzed the cases, I can say that though we have the name civil union, but in fact that's a partnership because the establishing documents approved that. I support the variety of the forms of the companies. I don't believe that everybody should be turned into the partnership. We just need to clearly establish the criteria. Apart from that, parties to corporate disputes could be physical entities found as members, shareholders of the commercial organizations of corporate types, so the managers or officials in the derivative actions, and any other person, provided the claim is well-reasoned and if their claims are linked to the rights when leaving the company. The legislation does not recognize as a separate member the ultimate beneficiary owner as the party or as the authorized representative of the non-resident in the corporate dispute. But the development of corporate liability that is widely discussed at the moment proves that these subjects should be included into the list because they are allowed to guide the activity of the company as shadow managers, as they are called sometimes. That's basically part of the doctrine piercing the corporate veil, and they should be held liable not only as part of bankruptcy procedure, but generally speaking, when it comes to corporate liability. In Ukraine, we have a practice of structuring business with involvement of foreign element, and and foreign jurisdictions, and that's reflected in the state register. I believe that ultimate beneficiary owner that is constantly permanently residing in Ukraine can be believed as authorized representative of a non-resident in Ukraine, and that will allow it to prevent the abuses when the non-residents are engaged in the proceedings just with the pure purpose of procrastinating it and delaying it. And well, we know that it happens because if the person resides abroad, it takes more time. The enterprises listed on this list are not commercial organizations. That's unitary enterprises, political parties, religious, charity type of organization, trade unions, the associations of apartment owners, self-governed organizations, professional unions, organizations, self-governing organizations of the bar, professional associations of the bankers, etc. The investment funds based on the shares. So all of them are legal entities, but they are not corporate type of organizations based on their activity. Given these criteria when it comes to corporate disputes, and given the fact that in these relations we often use special means of protection provided for by the law, in this slide you see the corporate types of disputes given different types of remedies that's challenging the acts or decisions of the subject of commercial activities, the identifying and collecting the payments with respect to the interest or share, finding invalid the statutory documents, so some parts of them that's the issues dealing with the preemptive rights of shareholders, that's the excluding the heir from the company disputes with respect to the title to property, and that was transferred as part of the equity capital action, suspension and reinstating the managers in their positions apart from labor disputes, liquidation, reorganization of the registration. In case of violating the corporate right of interest, the rights on collection of the dividends due, finding transactions or contracts invalid. Very often that's to do with the violation of corporate rights or the interests as to the property owned by the partnership, recognizing the title to the property, disputes arising from corporate contracts, etc. At the same time, the disputes that are seen in this slide are not corporate type of disputes, even in case of challenging the decision. But if it is done by the head company about the creditor or the lease, the disputes that appeal decisions of the managers or officials in the area of organizing and exercising commercial activity between shareholders, so the disputes between the members of the authorized capital authorized fund, family type of disputes, the disputes that deal with the heritage, bankruptcy, etc. So despite the same subjects, they are not going to be corporate type of disputes. And one other aspect of practical nature as to the exclusive territorial jurisdiction. A colleague already mentioned paragraph 6, article 30, that defines territorial jurisdiction. But from my point of view, it's poorly worded, because the idea of exclusive territorial jurisdiction was to provide for certainty and stability, to prevent abuses, where the person could file the claim in all jurisdictions. So we wanted to prevent the numerous disputes in different courts all over the country. But the second group of disputes that you see in this slide as a part of exclusive jurisdiction, that's the disputes that arise from the transactions or contracts on corporate rights, shouldn't be included into the exclusive jurisdiction. This should be alternative jurisdiction. Even if you appeal the decision of the managing body, the claimant does not reasons this by violation of corporate right. For instance, the procedure of squeeze out, that's the dispute that arises from the transaction. So you can appeal the decision of the supervisory board, but it doesn't deal with the establishment activity or termination of the activity of legal activity. So that's to do with the supervisory board, but the claimant substantiated that by the violation of corporate rights. And that's why, from my opinion, exclusive territorial jurisdiction cannot be applied here. Thank you for your attention. I'm not going to exceed my time, so let it be it. Thank you, Alexandra, for your presentation, and we've always enjoyed the cooperation with the commercial courts that we had with you. The floor is given to the head of the Department of Odessa Law School, Professor Tatiana Stepanova, the derivative claim and its role. Thank you for the invitation to participate in this important event that serves as a landmarking event in 30-year work of commercial courts in the Ukraine. I always say that commercial courts have a special role, not only among the specialized courts, but in the judiciary in Ukraine, due to the specificity they have, and they prove to be really effective in their work. My presentation is focused on a derivative claim, as it was mentioned, the specific features of the derivative action. Apologies. The specificity of this type of claim is the fact that at the moment we really have patchy provisions governing derivative claim. And we have a variety of different codes, commercial code, civil procedure code, the law on joint stock companies, the law on commercial companies, the law on limited liability companies. All these laws differently govern derivative claims. That's why that leads to various interpretations and misinterpretation of these provisions. And it causes difficulty and complexity for the judges, for the case law, and for all of us. It would be much better if we had uniformity of practice and certainty in this regard. Theoretical derivative action is defined as the right of the shareholders or members of legal entity go to court on behalf and in the interest of the legal entity to claim compensation for damages caused by the manager through the manager's action or inaction. including the fact when the powers of the person, of the manager were terminated. And it shouldn't be just action, but it also includes inaction of an official or a manager. If the person avoids resorting to any action, and if that caused damage to the person should the manager should be held liable for inaction. Another important thing here, this claim can be filed following termination of the powers of the manager. Well, it wouldn't be good if the person could avoid the liability by resigning from the partnership, having caused damage. If you sort of collect all the elements to characterize the derivative action, we'll have some specific features typical of derivative claim, and you see them in this slide. That's the way they are defined by legislation in Ukraine. The first thing is the claim is filed by the shareholder or member of a legal entity. That's very important. I would say that number 1 and 2 are interlinked. On the one hand, indeed, the person is kind of, indirectly involved in this. That's a derivative claim. So the legal entity gets some revenue, and the shareholder is indirectly, can indirectly benefit from efficient work of the legal entity. That's why the shareholder goes to court not to protect shareholders' corporate rights, but to protect the rights of a legal entity. If you follow this type of wording, then the second item should be fully reflected in the claim. The status of the claimant is given not to the legal entity, not to the person filing the claim, but the legal entity in the interest of which the claim has been filed. And therefore, it is legal entity that can claim damages based on the claim. So respectively, the action is not to protect the rights of not to protect the rights of a shareholder, but rather the legal entity. The action is filed with respect to legal relations that arose between 2 or more persons where the claimant was not party to. If you sort of try to imagine that, so the manager cannot file the claim, basically. If the founders agreed to some transaction, authorized some contract, that naturally the claimant that participated in the voting and confirmed the lawfulness of the actions of the manager and approved of the transaction won't be able to morally or procedurally to go to court to claim damages, because he himself authorized the manager to enter into the contract. So only if it was concluded when exceeding powers or with some other abuses, then only then the claimant can go to court. Another important element of derivative actions that makes them different from others, any legal entity is represented in the court by the management board, but it cannot be exercised in the instant of the derivative action, because the person that represents the management body is not interested in compensating damages. So we see the conflict of interest here in a way. So this scene then is used in the derivative action only in case when the managerial bodies avoid submitting a claim against the person that caused damages to the legal entity. We have a controversial practice in this regard when you can request the managerial body to file the claim, but if they fail to do so, the shareholder can submit the derivative claim. But the practice is not universal, and it's not always substantiated, since during the time the communication is exercised between the two, the representative of the managerial body can distort evidence or complicate the hearing of the case when it comes to evidence, etc. So I don't think that legislation should contain this element that the shareholders should go to the managerial board first and then go to court with when submitting derivative claim.
Подала, а юридична особа, в інтересах якої її подано. Тому ми кажемо, що це похідне.
So here we are saying that that's derivative claim. It's a claim in the interest of another person. Although in our case, it's not exactly the case, but the individual initiated the derivative claim would not obtain anything. If we look at the code of commercial procedure, we can see that these disputes belong to commercial jurisdiction at the location where such legal entity is located. Simplified proceedings are not admissible, as it was established by the Grand Chamber, and such judgment cannot be referred to any arbitration court or international arbitration court, because there are states where they have the jurisdiction subject to arbitration court, but our local corporate disputes can be considered exclusively in domestic commercial courts without any possibility to refer them to any additional jurisdiction. Talking about the officials who may be subject or held liable for compensation of damages in view of actions or omissions, now we do have provisions in the legislation offering the a list of such actions. As you can see, it reads any other culpable actions of an individual or an official. So let me start with the simple. What do we mean by culpable actions? That's point 4. It's very narrow. It's action or omission. It reads only action, but omission should be included not to make it culpable. But there is only one point that allows for holding individual liable when an individual is supposed to engage in certain action according to his or her professional or office duties. In other situations, we can try to hold an individual liable only if such individual implemented active actions. So, but all these actions then would be deemed as culpable actions that may be abuse of office, for example, or we cannot say that these actions are culpable. They should be just characterized with this feature. Or that may be the case when, say, director or a manager failed to comply with a pre-established procedure, and in such situation, this manager cannot refer to the fact that he or she was not aware of such procedure because this individual was certainly made familiar before he or she was appointed to the office. So it's clearly the guilt of the individual actions of an official undertaken under a different procedure of decision-making when an official was based on wrongful or false information in order to apply different procedure. Let's say there are situations when a manager may state that he or she was entitled to such actions because of decision of general meeting, but in such situations, we have examples where, let's say, such a manager failed to share some information with the founders before the decision procedure was made. Like, for instance, that such manager is a shareholder of another company. So the court should concentrate certainly on a very specific situation, specific enterprise, specific company, etc. Another point highlighted in red. This is about officials. This is an important point. We have some discrepancies on concerning which individuals should be deemed officials. Because if you read the commercial code of the law on joint stock companies or limited liability or additional liability companies, we would see different lists of individuals who are officials of such entities. Plus, our work is complicated with the fact that the legislation allows to include into the list of officials individuals who are stipulated by the bylaws or statute of a company. So when we look at these derivative claims and we analyze whether the claim was filed correctly, we need to keep in mind that this legislation, which limits the number of officials who may be subject to these provisions. Talking about the officials who speak for the company or legal entity are expected to act in the interests of such legal entity. And again, it's highlighted in red. This has evidential value for purposes of consideration of the case. The claimant, the stakeholder, participant of legal entity who defends the interests of the company and respective manager or representative of managerial body whose actions are claimed has an obligation to work in good faith, never abuse, never outreach the duties. So in this case, such manager would need to prove that he or she has done everything correctly according to the norms and rules.
Попередніми доповідачами і взагалі хочу відзначити, що практично у всіх доповідях
Also, I'd like to mention that all of our speakers tackled with this issue of derivative claims, which shows that this construct, this idea is very useful and efficient. It's widely used for purposes of commercial lawsuits. So this participant of a joint stock company who owns more than 10% of the joint stock has the right to use this derivative claim procedure. But here it's not clear whether we are talking here about one individual or maybe group of individuals who own jointly 10%, because if you read any law on our companies, corporate legislation, etc., the wording there is different. All of them read owner or more than one owners owning jointly 10 or more percent. But here everything is clear. If they are shareholders, like 10 of them who own 10 shares, can then collectively file a derivative claim to protect the entity. But the wording used in Article 54 are certainly incorrect, and it certainly needs to be brought in correspondence with the aforementioned legislation, because certainly we don't want any unnecessary restrictions, because if it's just one owner, then it's certainly a restriction, because there are many powers which are essential for live activities of commercial company are implemented through joint empowerment and through collective ownership of the shares. So certainly this word needs to be corrected. Talking about further details of some elements that are not properly recorded in the law, but they ended up being important for purposes of judicial review. And those that I think need to be included into legislation. First, it's about signing any agreement or transaction by director without previous consent of the general meeting may violate the rights of the legal entity, but not the corporate rights. So actually, the legislation should emphasize that this is not about the corporate rights. So any proceedings in the courts of lower instances failed to keep in mind that there was the High Commercial Court judgment with regard to potential activities of abusers, but this kind of abuse that was subject to judgment of the High Commercial Court need to be mentioned separately. This is a very popular way to abuse the managerial rights by the managers, and certainly it should be clearly stated in the legislation that any manager is aware that he or she may be subject to prosecution. Talking about labor relations, I mentioned that already, that even after they have ceased, it is possible to file a lawsuit. Four main components that need to be improved is the nexus, the guilt, and as far as guilt is concerned, I'd like to say that in the commercial law, we do not have presumption of innocence as the criminal law has. We has the presumption of guilt, so of course, it's not possible to enter a manager's brain and to prove that he or she had this intention, or just it was merely mistake. So the guilt should be defined very clearly as negligent performance of the duties. And only in this case, we then would be able to hold liable such individuals, not just basis of the case law, but based on clear legislative provisions. So the both parties would then have understanding at the point of the claim what they should expect. Another word in is expression of will. The real expression of the will, I think we should consider it as part of manifestations of abuses, where we talk about compensation of damages, and another a large component. It's quite a long-lasting violation when an individual has been engaged systemically into improper actions, and in the end, that led to accumulation of big amount of losses just because of the systemic violations. So this probably situation should be examined and actually stipulated in the legislation separately, and talking about wrongful behavior, which consists in activities that are taken without considering the normal commercial risks. These points are very important, but this is just the case law. And I'm sure that all these points that I've mentioned certainly need to be regulated at the level of the legislation, because this is the way for a potential offender to know in advance which steps he or she should refrain from in order not to be punished and in order not to have later on to compensate the caused damages. I think we'll have much fewer cases after that of this kind. Tatiana, thank you very much for very informative presentation, and especially for this assessment of commercial courts. You mentioned that these courts have proven their validity and their effectiveness. And now the presentation is by Valery Vihibelko, judge of Commercial Cassation Court. He'll talk about appealing by a member of legal order of transaction concluded by the executive body of that legal body. Please, the floor is yours. Yes, good afternoon, everybody. I'm very thankful, first of all, to our esteemed academia, who made very interesting presentations. I didn't even have a cup of coffee because certainly we are missing the scientific analysis of statements that we made in our judgments. And, you know, we generate a lot of judgments, so if somebody can take a look from outside, it always would be very useful. I hope you can see my presentation. So the subject matter is very interesting. I've spoke a lot on this subject matter in many round tables, and I may seem as a, you know, this masochist who talks again and again about very painful thing, because I remember that my position was not actually accepted by many judges, and I faced the situation when all of them would challenge the determination that the Grand Chamber delivered. So I'd like to say Because it's very important that our determination be not only rightful, not only fair, but also persuasive for judges who will then refer to our determinations, and for lawyers who read our determinations and pay attention to our legal positions. So first, I'd like to say what actually determination I'm talking about. That's determination delivered by Grand Chamber of the Supreme Court as of 8th October 2019, which, after being promulgated, drew a lot of attention of academia and lawyers, and also generated a lot of criticism. So why did that happen? Why the lawyers were not happy with that? First of all, a few words about the case as such. There is a participant of LLC files a claim with the commercial court requesting change in terms and conditions of a lease agreement concluded in 2005, then amended, and this individual referred to a non-friendly takeover. So there were some conflicts inside. So the Great Chamber analyzed the situation, referred to civil code, to the legislation concerning commercial companies, concluded that a party to this agreement concluded by the company is the company, not a participant, and the legal status of participants does not change. There are powers to act on behalf of the legal entity. It was the limited liability company at that time, and the participant cannot form his or her own legal will.
And violation of the rights and interest, or signing the contract without the consent of the higher authority of his company. I will speak about the violation of the rights and interests of the company itself, rather than corporate rights of the members of the company. So the party cannot go to court and cannot claim of finding the contract invalid because the rights of this person are not violated. It was the company itself that should go to court with the respective action. What was the deficiency of the resolution? It's not because it was a wrong position or the judgment was not fair. I think that the reasoning should have been more detailed so that we could understand better what was the judgment based on. Naturally, any resolution of the court cannot be turned into the PhD, into the dissertation or theoretical research, but we need to look at the criteria and principles of the corporate law and corporate governance in this judgment. So we should be governed by business judgment rules. So the court shouldn't interfere with the commercial activity of the company, as the court shouldn't replace the management of the company or the general manager, and the court shouldn't assess the business decisions of the company, whether it was effective or not, whether it was sold cheaply, costly. Well, it's not for the court to decide. The second aspect, legal entity, is the owner of the property. Well, we had detailed explanation saying that shareholder is not the owner of the property. A legal entity as the property owner shapes decisions through the decisions of the managerial bodies, well, through different forms of activity, and there should be a respective decision for transaction in question. In some instances, there could be a decision of supervisory board, general meeting, any managerial body that the company has. The person, member of the company, can agree or disagree with this decision, but the members should execute it, and the decisions are made not by a unanimous decision. Even if the person believes this transaction unprofitable, he or she should execute that upon its approval. If the manager made a decision without the decision of the general meeting and it was required, then it is the company that is to respond to this somehow anyways. But well, we heard that in some opinions of the court, it was stressed that it is necessary to maintain the balance. Well, if you have the company, so we have some authorities in this company. So general meeting, supervisory board, executive authority. The members are different, minority, majority, the former ones. But here we are talking about the will that they can exercise on the decisions made by the company. The person by its own cannot shape the decisions, and that was the theory behind the opinion of the Grand Chamber I referred to. After this opinion, we had several other resolutions of the Supreme Court that should be noted here. And one of the recent ones dated February 17, 2021, states that very often we refer to the European judgment Feldman and Slovensky Bank versus Ukraine, but the corporate veil in this case is the barrier that exists between the managers and legal entity, and so piercing the corporate veil or neglecting the legal capacity of the company can be justified only under exclusive circumstances when it is clearly established that the company cannot go to the traditional institutions. It is very important to note here. The position of the Grand Chamber expressed in the resolution of December 17, 2009. Can it be changed? It seems to me that it was probably the only case when for 3 times they repeated the initial position and stated that they don't see any reasons to review it again. And while in the subsequent resolutions, the Grand Chamber substantiated its decision why they don't see any reason to review this case again or review the opinion. You can just check the reasoning part yourselves, and while they provided additional grounds to look at more substantiated. We found 15 subsequent resolutions with reference to the initial position of the Grand Chamber, and well, you can find the references in different resources, and you'll see that there are thousands of reference to this resolution of the Grand Chamber in the judgments of the courts. So this allows me to say that this position is not going to be changed in the near future, at least. And thus we have a question: how minority shareholders can protect their rights, whether this opinion of the Grand Chamber, whether this position of the Grand Chamber allows for this protection in case of the infringed interests. We have a lot of resolutions of the Supreme Court where it was stated that the party that is not party to the contract whose interests were infringed by concluding the contract in question can go to court and seek this contract be held invalid. So do the parties have sufficient rights to protect their interests? The case law says that and we spoke a lot about this today, about the means of protecting the rights of the person. If that's the share that makes 50 or 60%, that if that's controlling interest, then the person can mandate the CEO to go to court or replace the CEO. So there is no point to go to court to find the contract invalid if the corporate rights of the person were violated when we look at these instances. Very often the person whose interest was like 10% or more, and we ask them, okay, why don't you go to court? Because the, well, there were some violations. Why does the company go to court? And very often the response was that the company went to court and it was dismissed. It means that very often the company tends to try and resolve the dispute another time because in the initial claim, so this claim was dismissed. So that's another proof to show that the position of the Supreme Court of the Grand Chamber was the right one, because this does not allow for repetitive claims submitted, especially in the instances when the first or initial claim of the company was dismissed. The person with 10% and more can file the derivative action to claim damages. This is relatively new case law that we see accumulating in the country. So more and more often people do that to protect their interests. If it is LTD, then the person can leave the company. If the person is not happy with the decisions of the general meeting or the way the business is conducted and decisions made, the person, if the person disagrees with the strategy, can leave the company and can claim money based on the bylaws. And then again, you know, you can claim damages and hold the company liable, or any other physical person if it was the case, CEO, etc. So, well, it could be the creditor, third parties. If that was the case, then you can protect your interest by claiming damages from whoever caused this damage. In Anglo-Saxon system of law, this type of claims are really popular to protect the interests. Well, so that's rather this type of claim rather than finding the decision or contract invalid. So the decision was made, but the decision was detrimental to the person. Therefore, the person can claim damages. So that this type of claims are really very popular in the Anglo-Saxon type of countries. And a few other resolutions that were mentioned by previous presenters that reinforce the possibilities of protecting the rights by member of the company. That's the resolution of October 22, 2019, where Article 232 of the Civil Code of Ukraine was applied, and it was stated that this article can be applied when finding the solution when settling the dispute on finding the transaction concluded by the manager as the one that was committed as a result of ill intention or complicity of the company with the other company. And well, you need to prove that this transaction was committed against the interests of the company, and you can resort to different articles, different legislation. In this case, it was Article 232. The Grand Chamber stated that the person that acted on behalf of the legal entity are to act diligently and reasonably. They defined unlawful conduct, and due to that, the transaction was found invalid as a result of the complicity of the agent and the manager of the company. Another resolution of December 3, 2019. Here again, it was an attempt to find invalid the transaction by the person who owned 3.5% of the authorized capital. It was selling of property at the lower price, and the person had only 3.5%. If this transaction were committed and the company did not challenge it, then it means that the company was authorized to do that. So the person couldn't agree with that decision, but the person owned only 3.5% and couldn't have an impact on the decision made. Well, there are some other means of protecting the rights, and the Grand Chamber says that there should be a balance of interests of all members of the company. My apologies. The time is expiring, and in fact, in this resolution, they list all these methods of protecting the minority rights. And derivative action, just a few things on that. Well, it should be governed by amending legislation on derivative actions, because if it is uncontrollable right of going to court, that would be given to the persons, might lead to a legal case, because the company can enter into a contract where conduct transaction, and then anybody can go to court to find it invalid. But again, Article 71 of the law on the joint stock companies, it is said that the transaction with interest can be found invalid upon the claim of the member of the joint stock company. We see the expansion of the scope of the application of the derivative action, but it shouldn't be just the opinion of the shareholder on that, whether that's abuse or anything that the claimant based it on, but it should be independent assessment that should be conducted on that to conclude that the transaction was concluded under the circumstances worse than any other market conditions. So that's the right way to move on. If you see that the position of the Grand Chamber of the Supreme Court does not allow to provide for legal certainty. I'm sorry, but you don't have time. And the last resolution, that's a new one, and there was a lot mentioned today about holding the CEO liable. So in this resolution, the focus is on the guilt, and it is not the claimant that should prove the guilt if that's the claim against the company, but innocence should be proved by the respondent, and yeah, that's an important to note. Thank you. Thank you for your attention. I can conclude now. Thank you. Thank you. Bye. Dear participants of our roundtable, we are going to have a break now, a short break. We'll resume our work at 1:30 Kyiv time. Thank you.
Prevail in the case law of the European Court and the Supreme Court. I'm giving the floor to Irina Kondratova, Judge of the Court of Cassation as part of the Supreme Court. Please, the floor is yours.
Good afternoon. Thank you for the invitation. My congratulations on the occasion of 30th anniversary of commercial courts. The topic of my presentation is quite interesting. For quite a long time, we face situation when creditors have no possibility to get money from debtors. And the reason is absence of liquid assets to meet the requirements of creditors. Such situations are encountered not only in Ukraine, but in some countries. In the history of corporate law, there are some mechanisms of protecting rights of creditors in such cases. One of them is the doctrine of penetration of the corporate veil that was first used Anglo-Saxon law doctrine, and later it was used in continental law system. This legal doctrine and the availability of situation that this doctrine should be used caused the need to use it in adjudication practice. There are different synonymic concepts for this penetration of corporate veil. Peering under corporate veil, piercing under corporate veil, taking into account the character of implementation of this by domestic sort. I think that for Ukraine practice, non-uniformity of terminology only causes difficulties in translation, but it doesn't have importance of fundamental nature. A company is only a cover, a facade for activity of its owner, and decide who should be responsible for violations and for meeting the requirements of creditors. This doctrine allows to lay responsibility on shareholders, on the company, or other affiliated legal entities. In Ukrainian legislation, this doctrine of penetration under the corporate veil is not used directly, but you can find it partly in some legal acts regarding particular aspect of responsibility of founders or owners. Responsibility of founders, owners, or shareholders of a legal entity that is recognized bankrupt, whose activity caused damage to the bank because of their guilt. When corporate enterprise, because of the activity or inaction of this company, becomes bankrupt. Although in Ukraine legislation, we don't have this direct doctrine penetration under corporate veil. In some circumstances, court penetrate under the corporate veil based on the cases of European Court of Here, Agrotexit scheme and others, Feldman and Bank Slavyansky versus Ukraine and others. European Court in its practice uses two approaches in penetration under the corporate veil. First approach, direct approach, so-called traditional approach. In that case, one studied the reasonability of taking founders to liability regarding legality and proportionality. Khodorkovsky and Lebedev versus Russia, the court agreed that when limited liability companies used only as facade for fraudulent operation for owners and management, One of the possibilities to protect creditors' rights is to penetrate on the corporate way that separate property of the company and property of the owners or managers. But one needs legislative basis. At that time, neither tax code or civil code of Russia didn't allow take money from these companies. And the court ruled that shifting responsibility was discrete. Other case, Lekic versus Slovenia, Grand Champion of European Court, by its decision of 2018, on the contrary, ruled that engagement of the founder and director of the company without procedure bankruptcy to liability is based on item 1 of protocol 1, and penetration under the corporate veil was lawful. The law on financial operation of companies, Slovenian national courts got the right to use this doctrine and bring active participants of company to liability. Slovenian government developed this law to ensure financial stability. At that moment, there was a great number of so-called sleeping companies that had big debts, not insured by any assets. European Court ruled that an applicant was an active participant of the company, owning more than 10% of statutory shares, that gave him the right to get information about activity of company, right to call general meeting of shareholders, and decision regarding calling it bankrupt. That was important factor for making decision in the case, because Lekic didn't use the procedure of bankruptcy to achieve balance between interests of society and measures used by applicant. European Court ruled that the government is obliged to prevent damage to interests of the country and facilitate trust. Second approach is the contrary approach. Use of this doctrine of penetration under the corporate veil, status of a victim according to European Convention, and the right to go to court. First principle, using this doctrine, penetration under the corporate veil, in case Agrotexim versus Greece, when deciding whether shareholders could be called victims, they ruled that could happen only in exceptional circumstances when the company cannot apply because of statutory condition or because of liquidation. The principle used in Agrotexim case, despite being used for protection of property, remains general, and it covers other article of convention. Feldman and Bank Sloviansky against Ukraine. Bank was under control of liquidators, and local tax inspectorate, who were members of liquidation commission, shows that shareholders and the board of the bank could not influence activity of the bank. That gives majoritarian shareholders the right to apply. So there are two different cases. In the first case, European Court rules that measures aimed at penetration under the corporate veil. The other, use of the same doctrine when the application was admissible. As regards the reverse principle of penetration under the corporate veil, the court also considers this doctrine in the interest of legal entity. The principle is the judgment of cassation court in the case where the limit liability company participant having 65% of shares appeal against decision of the court regarding the general shareholders meetings. European court, Ukrainian courts allowed to do it only if it is prescribed in the founding documents of the companies. But now use of this doctrine penetration under corporate veil allows to conclude that in exceptional cases, this participant could act on behalf of the owner, on behalf of the legal entity, while protecting personal institutes. In this case, commercial court came to conclusion that there are exceptional conditions that allow participant of this company to go to appeal court with his complaint, and ruled that decision of the general meeting of shareholders was unlawful. The complainant is a member of this company having 65% of shares, and the company itself has no possibility to use procedural routes and act in the court because this legal entity is in liquidation. And the issue of termination of its registration is not decided finally. Therefore, the participants of this entity can go to court with complaint because this company itself has no possibility to do it. It is in line with the case law of European Court. Penetration under the corporate veil could be justified only in exceptional circumstances. It was found that this company could not go to judicial institution because of what is written in a statute or because of liquidation. According to the decision of European Court of versus Greece, the court ruled that it was a correct decision. The court ruled that corporate veil could be penetrated in favor of participants who wants to protect rights and interests of legal entity. Activity which is terminated, and cannot use its procedural rights in court. I couldn't find other cases like that. Other case of the Board of Commercial Court. Corporate veil is a barrier that separates its participants, doesn't allow them to go to court and protect the rights, because you cannot identify the legal entity and the applicant. In this case, there were no exceptional circumstances that European Court mentioned in Feldman Sloviansky Bank versus Ukraine case. And therefore, it's not possible to penetrate under the corporate veil and admit this application because this company is not liquidated and it can act according to its statute and legislation. We have sufficient grounds to conclude that case law shows that it's possible to use the doctrine in penetration under the corporate veil, and it's being implemented in domestic legislation. It can effectively help to fight between illegal practices and increase social responsibility of business, and protect effectively right in interest of shareholders, given the possibility to a shareholder to act in the interest of the company. Thank you for your interesting presentation. Thank you for agreeing to speak at our roundtable. Judicial control over decisions of general shareholders meeting in the field of corporate law. Christoph Schert, Professor, Doctor of Law, Dean of the Faculty of Sociology and Law, University of Applied Science in Heidelberg. The floor is yours.
Mr. Chairman, ladies and gentlemen, thank you very much for the invitation. It's a great honor and a pleasure to be here and to take part in this wonderful round table. I'm happy to share some thoughts concerning the judicial review of general meeting resolutions and its current differences with you. As we heard before, a lot of corporate raiders, and as the president, Staniszewska, already mentioned, the special role of courts to protect the justice and to protect minorities. Hopefully my theme will also find your interest. So before we start and we jump into the main problem, let's have a look at the dogmatic framework and its current challenges in Germany. As you all, of course, know, the German stock corporation law, as most of the continental legal systems, is based on a triangular balanced relationship between the general meeting, the management board, and the supervisory board. and its hereby installed system of check and balances. Today, I want to focus my contribution on a general meeting, in Germany so-called Hauptversammlung. As you all know, the general meeting, regulated in Articles 118 and sequence, plays a very important role. It is the convent of all shareholders and therefore the central statutory body for deciding fundamental structural and strategic questions. It makes its decisions either by simple or, in case of important changes to the structure or the financing of the stock company, qualified majority, whereby the latter normally requires a 3/4 acceptance by the present participants. Due to the resulting possibility of majority decisions, we are facing a typical conflict of interests. On the one hand, the legal order has to guarantee the necessary protection of minorities and to prevent collective oppressions and violations of law. On the other hand, the prevailing majority has a legitimate interest in a low-cost, efficient implementation of lawfully adopted structural measures and other general meetings resolutions. Especially in times of crisis or threatening insolvency, time losses might significantly reduce the remaining chances of success and even lead to the complete downfall of the stock company, as seen, for example, in the famous cases of Pfleiderer, a world leader in German specialist wood processing company. What are the typical instruments to safeguard the minority rights? From a doctrinal point of view, we should distinguish ex ante and ex post safeguards. One pillar of the ex ante instruments is the implementation of strict formalities to guarantee minimum participation and information of each and every single shareholder. In this context fall all regulations concerning the invitation, convening the general meeting, or as well as the stockholders' right to request information. Another effective protection mechanism are the requirements of qualified majorities, either given by law or by the articles of incorporation itself. And finally, qualified majorities are vested with the right to start special audits via judicial decisions, whereby the special auditors have specific and effective rights to audit the books and records and the company and its assets, and to further investigate any potential damages. But of course, in my opinion, the most important and most effective instrument is the ex post judicial review of general meetings resolutions by civil courts, which brings us to my actual topic of this short presentation. As you can all imagine, this possibility of judicial and therefore governmental review of private autonomous acts of will needs a proper balancing of diverging interests described before. Whereas the majority wants to achieve the most constitutive commercial registers entry as soon as possible, court proceedings typically take up precious time and money, and in the event of success, force the company to completely restart from scratch the complex resolution procedure with all its pitfalls and challenges. The German Stock Corporation Act therefore stipulates a complex system of fault consequences according to the severity and importance of the alleged defect. Whereas severe defects automatically lead to the nullity of the general meeting's resolutions, for example, in case of serious errors or of the invitation convening general meeting or the violation of public policies, the normal consequence is the simple voidability of the resolution, whereby the German Stock Corporation Act provides detailed rules to court criticize the judicial procedure. Only in cases of minor defects, the German Stock Corporation Act holds the general meeting resolution and refers the parties concerned to claims for compensation for damages. Finally, first and foremost, in cases of disputes arising out of valuation issues, the re-examination is transferred to a specialized judicial body, the so-called Spruchverfahren. Although from the theoretical starting point, the German and continental system seems to provide a fair balance of interests, the pure possibility to challenge the general meeting's resolution by an action for avoidance attracts people to provoke faults of the general meeting resolution and to try to convince the company to buy off their rights to sue. Thus, this so-called corporate raiders misuse the legally provided minority rights to blackmail the companies and to gain individual benefits. This is the in German very popular case of corporate raiding. As we heard before in other contributions, you described a different sort of corporate raiding, but in Germany we find this specific way of corporate raiding, which is quite popular, and we call it even a business model of corporate raiders. In spite of long-time discussions, many interesting proposals of legal experts and almost continuing amendments to the law, this phenomenon is still unresolved. Currently, the German Stock Company Act installs a special proceeding to overcome the factual blockage of commercial register entries and its often existential threatening of the continuance of the company. While this procedure significantly reduced the phenomenon of corporate raiders in Germany, its dogmatic design is almost universally criticized and rejected. Why? This is the big question. And why do we still keep on it? Reason for my negative evaluation is its incompatibility not only with the traditional principles of interim relief, but its de facto denying of minority rights and its bypassing of small shareholders. Thus, the court can order the commercial register's entry not only in case of a failure to achieve the required quorum of a stake of at least 1,000 euros, which is quite an amount of money indeed, but also in case of prevailing disadvantages for the company and its stockholders vis-à-vis a single shareholder. And it's important to mark vis-à-vis a single shareholder. So the widening is between the interests of the enterprise versus the interests of a one single specific shareholders. And as you can always imagine, the latter is very easy to demonstrate and therefore regularly leads to the court order for the release of entry. So in fact, by this procedure, normally it's very easy for the company to overturn the actions, which was indeed the original intention of the legislator. But it's also a very unsatisfactory legal situation because minority rights are quite vested in this case. So, may I use the remaining speaking time to briefly sketch my own proposal for this question? I'd like to suggest a three-step model using procedural precautions to stop the attractiveness of corporate raiding and provoking defective general meeting resolutions. And that's why hopefully this is interesting for you and the court, because now the court plays a very important role in preventing corporate raiders. First step should be the possibility of a single stockholder to seek a preliminary judgment stating the voidability of the general meeting's resolution. Its access barriers should be very low due to the fact that on the second step, and this is very important, in case of an affirmative preliminary judgment, the stock company should have the possibility to confirm its resolution within a certain time frame. My personal suggestion would be 3 months, and widely supported by digital instruments like online information and online voting to make it very cost effective and a very quick solution for the companies to overcome curable defects. The final step 3 formally ends the judicial reviewing process, either with recognizing a successful ex post confirmation of the general meeting resolution and the accompanying cost decisions, or with the final declaring the contested resolution as null and void. This would be my concept. These 3 steps: preliminary judgment, possibility to affirmative and confirm the resolution, and final step, judicial final decision, ex post confirmation of the general meeting's resolution. What are the benefits of my proposal? First of all, and I think this is also a big benefit, it's completely consistent, not only with the concept of corporate law suites, but also with interim relief procedures, because the success of the plaintiff depends only, and this is important, only on the perspectives of success and the factual existence of a faulty general meeting resolution, not the quorum or any other balancing of interests as in the current status quo. Second, the procedurally implemented possibilities of the stock company to affirmate the original defective resolution eliminates every corporate raider's business model due to the fact that possible remedies no longer include the blackmailing potential. At the moment, there's a big potential to provoke faults by either asking so many questions you can't answer within the time or other means, and then to let it buy off. And because of this buying off process, and because of the costs are out of this, it's very attractive to be a corporate raider. But in this proposal, even in the case of a judicial attestation of errors, the company is no longer in the position to restart the whole complex resolution procedure. It can easily override curable and provocable errors by a low-cost, fast implementable confirmation process. And at the same time, due to the low access barriers, minorities worthy of protections benefit from an effective instrument to challenge non-curable faults and therefore unjustified interferences with their property rights. So altogether, my proposal should provide a well-balanced, innovative solutions to a long-time unresolved problem of corporate raiders by giving the courts the decisive role to make a very clear and structured procedure to help companies overcome corporate raiding. But is this the only field of application? No, in my opinion, this concept, you can use it in different phases and different legal surroundings. The here suggested combination of preliminary procedural remedies with the possibility to cure provocable defects may be useful in all contexts in which minority rights are abused to gain individual advantages. Therefore, the courts and their procedural instruments can play an important role as neutral decision-making authority and guarantor of procedural justice. And we come back, as we said before, the courts are the important safeguards for justice. With this, congratulations to the 30th anniversary of the court, and thanks for playing this important part in our corporate law system. Thank you very much. And if there are any questions, feel free to ask now or later in the chat. Thank you very much.
Ми дякуємо, Кристоф.
We want to thank you, Mr. Schertl, for telling us about the corporate laws of Germany, Stock Corporate Act of Germany. And let's proceed to the next issue, corporate conflicts in Canada, the review and the latest developments. I'm giving the floor to Herman Welton-Ziegel, Judge of the High Court of Ontario, please.
А скажіть, будь ласка, у нас приєдналися пан Герман Welton-Ziegel?
Whether Mr. Herman Welton-Ziegel has joined us?
Проте не вимкнений мікрофон у нього. Зараз ми його попросимо.
Будь ласка, будь ласка. А якщо тут зараз він вимкнений?
Mute your microphone.
I apologize for that. I was unmuted. There we go. I assume you can hear me now?
Yes, yes, we can hear you.
Yes.
I apologize for that. I want to start by saying I'm very pleased to be participating in this session, even if it's required an early morning rise here in Canada. I'm going to address two categories of subject. The first would be some important aspects of corporate law in Canada that we see regularly in our courts that relate to corporate disputes. And the second will be to describe in very brief terms how we go about the process of controlling and adjudicating cases. Let me start by saying that in Canada, in Ontario, we have a specialized commercial division of our Superior Court, which hears cases in two principal categories. The first is corporate disputes, and the second would be major corporate reorganizations. At any given time, there's a roster of 15 judges based on their previous background. In my case, I was a corporate lawyer. 6 or 7 judges will sit regularly on a 24/7 basis to hear cases that arise of this nature. Very quickly, we of course have public and private corporations in Canada. The vast majority would be small and medium-sized businesses. The bulk of our cases in the commercial division would be larger private corporations and some public corporations, principally dealing with shareholder meetings and proxy fights. The rest of the issues relating to public corporations are governed by securities legislation, and they would be heard initially by our Securities Commission and then heard in the commercial division on appeal. So what are the bodies of law that govern corporations in Canada? Well, there are 3. The first would be corporate statutes. There's a federal statute, and then each of the provinces has its own business corporation statute. In terms of private corporations, they're pretty much identical. The differences would relate to some features of public corporations. The subject matter of these statutes would be quite familiar to you, and I've addressed some of the principal matters on the slide. I want to deal with one because it relates in part to one of your subjects today. We have a concept of fundamental transactions, amalgamations, sale of all or substantially all the shares of the corporation, major reorganizations and the like. While our statutes typically only require majority approval by shareholders, these kinds of transactions require a supermajority of 2/3, but more importantly, where they would involve the majority increasing its shareholding interest, for example, in an amalgamation squeeze out, we have 2 additional requirements. The first is that the shareholders must be provided a fairness opinion or a valuation opinion by a third party prior to the vote, and there is an additional voting requirement of a majority of the minority shareholders. So then I mentioned securities legislation. It does govern private corporations in respect of the issuance of shares, provide some protection where shares are being issued to parties who are not related to the existing shareholders. And lastly, we have a body of common law across the Commonwealth, really, that developed the general principles of corporate law before the institution of corporate statutes, and considerable interpretation of those statutes now as a result of decisions in courts such as ours over the past 50 years.
Your Honor, excuse me, we cannot see your presentation.
You can't see my presentation?
No, we cannot see your presentation. I'm sorry.
I'm very sorry. I'm on screen sharing. I'm not sure what the problem would be. If there's someone who on the technical side can assist us. I can try and start it again. Would that be helpful?
Yes, it will be helpful. Please.
Okay.
Thank you.
I will.
I believe Alexander has to be here with us. He is our technical. Okay, you can also send it to operator KLS, and they will share it instead of you. You will just tell them when they need to press for another slide to be shown on the screen.
That's fine. Do you have this? You have the slides, do you?
No, we don't. But can you
send the slides to you?
Yes, I will. I just messaged you.
Okay.
Thank you so much.
The slide presentation is actually with the organizers in both Ukrainian and in English. Perhaps with the Council of Europe, you can have the translators or the moderator post the Ukrainian version on the slides when Justice Siegel is speaking. You may have to reboot your own presentation, Justice Siegel, as well, because it only shows a fragment of your screen and the first page of the slide in very small section. Now we have you on the screen exclusively.
You have me, yes, because I have left that.
Sorry, у мене просто захід, тому я тут не можу включити це.
Go into let me see. I can find the slides now.
You just open the slide presentation and just press shared screen after that.
Well, that's what I've been doing. I'm going to try that again.
Модератор, ви теж маєте копію цієї презентації у обох мовах. Може і ви можете українською мовою висвітлювати.
Moderator also allegedly has copy of slides and can show it.
There we go.
Are you back on? Are you on now? Do you have my slides now?
Yes, we do. It's on shared screen.
Perfect. Thank you.
Okay. I'm very sorry about that. I got to the point where I was going to describe the actions that appear before us in the court in respect of shareholder disputes. And I'll describe three categories that are basically internal to the court and one to the corporation and one which you might think of as external. The first would be actions between shareholders for control of a corporation. And we see this principally as a result of breakdowns in relationships amongst the shareholders or deteriorating financial conditions. But a very important phenomenon recently has been what we call intergenerational disputes, where a corporation, for example, would have existed for some time, having been founded by 2, 3, 4 shareholders. After the death of one, acrimony develops between the estate or the beneficiaries of the deceased shareholder and the remaining shareholders, and there will be issues of control. The second would be actions by some or all of the shareholders against directors in respect of issues stemming from financial losses of the corporation and responsibility for that, and in respect of actions proposed by the corporation, for example, fundamental transactions. And the last, which involves some overlap with the first two categories, but is the largest source of our caseload, would be actions by minority shareholders against the majority shareholders in circumstances where the minority feels that it's being badly treated. The last category would involve actions by third parties against the corporation for losses suffered as a result of contractual breaches, for example, or non-contractual tortious actions, what in civil law would be known as delict. Increasingly, we're presented with actions not just against the corporation, but against the directors and officers who are alleged to have caused the loss. We do have a body of law that can attribute liability in those circumstances, but it is relatively restricted. So what are the natures of the claims that are asserted in these actions? Well, they fall into two categories: common law claims and statutory. The common law claims, which I set up on the board, would undoubtedly be very familiar to you: breach of various duties of the directors, fiduciaries, or statutory obligations, breach of contract if there's an agreement between the shareholders. But I'm going to deal with one last one, the bottom one, misappropriation of corporate opportunities. We have a very important principle, and we see more and more of this, particularly in real estate development companies, for example, that applies where a director or an officer has identified a corporate business opportunity that it wishes to take advantage of. And under our law, if the corporation of which he's a director or officer has a mandate that includes that kind of opportunity, it must, that's the director or officer, must first offer it to the corporation for a decision by the directors as to whether or not they want to take advantage of it. If he doesn't do so, and the director or officer subsequently profits from that business opportunity, the corporation can have a right to claw back those profits. And we see a number of actions in that regard. I turn next to the three statutory provisions that are very important in our case law. The first, the oppression action, is clearly the most important, and in many ways it has replaced the common law claims. It's a very broad action which grants parties a right of a remedy if, in their view, the corporation, the court finds that the corporation or the directors have acted in a manner or threatened to act in a manner which is, and I now cite the statute, oppressive or unfairly prejudicial to or unfairly disregards the interests of, and the parties who can claim are a security holder, corporation. So it's a very broad remedy, principally directed towards protecting minority shareholders whose interests are unfairly disregarded by the majority. And the importance of this as well is that under our statute, the court has very flexible remedies and a mandate to fashion a remedy which is specific to the issue at hand and that rectifies the oppressive behavior. The second action is the derivative action. I see you're addressing it too, and it may be we have the same concept. In Canada, a derivative action is a legal proceeding commenced on behalf of a corporation against a third party by the minority shareholders in circumstances where the board of directors have typically refused to proceed with such a legal proceeding. And while it can be directed against parties unrelated to the corporation, it is more often used as a strategic weapon by minority shareholders against the majority shareholder or directors and officers. And the specific benefit it has, among other things, is that the corporation, rather than the minority shareholder, will bear the legal cost of the proceedings. And the last, which didn't make it on your screen, is the just and equitable winding up action. We have a recognition in our law that many businesses, including many large private corporations, while they are carried on as corporations, are effectively partnerships amongst the parties. And as partnerships, they rely very heavily on relationships of trust and confidence amongst the partners. And when that trust and and confidence breaks down, if the parties have not themselves provided for a means of what you might call a corporate divorce, of going their separate ways, our statute provides that the court can and should step in and fashion a remedy that will allow them to do so. And again, we have very broad powers to fashion something that would be appropriate in the circumstances. For example, we can authorize an auction, we can authorize a sale by one of the partners to the others, or a mandated sale to a third party, or some other form of dissolution. Very quickly, I can comment on a couple of developments occasioned by the pandemic, which might be of interest. The first is we have seen a great increase in shareholder disputes occasioned as a result of financial pressures suffered by the corporation due to reduced profitability and cash flow, particularly in the areas of funding, proposed funding arrangements to get the company through the pandemic, and or allegations of responsibility for loss, human nature being what it is. Minority shareholders tend to blame the majority shareholder and the directors and officers rather than the economic circumstances for financial losses. We've seen an significant increase in insolvencies, particularly in the area of real estate and in real estate development and in the retail area. And we have seen a number of cases, major cases, where parties seek to rewrite or suspend commercial obligations as a result of the unanticipated circumstances of the pandemic. A good example, we see it in M&A agreements all the time, but we also see it in the context of commercial leases where major tenants want a rewrite or a suspension of their rental obligations. We do have in the common law a concept of frustration of contract which can be available, but it's only available in very narrow circumstances. So lastly, let me spend a few minutes and describe how we handle corporate cases, which may be of interest to you. We have two types of applications typically before the commercial list. The first would be applications that require immediate attention and decisions, such as opposition to a transaction that the corporation is proposing, and others which and would form the bulk of our work will be worked out over a long period of time, 2, 3, 4 years even, such as, for example, complex trials for damages based on past actions, and certainly for corporate reorganizations. So in respect of each of these cases, as soon as they come in, we assign a judge as the case management judge to these cases. That judge is available, as I say, 24/7. But the important point is that the judge will be involved not just in hearing whatever proceedings are brought by the parties from time to time, but in actively managing. So, for example, meeting with counsel on a regular basis to discuss the status of the matter, to discuss the issues, to discuss what the next steps will be, and to discuss and to set the actual schedule. And that provides a lot of room for active involvement, which I'll speak to in a moment. Since the commencement of the pandemic, we have gone entirely to Zoom hearings, and the council are now very comfortable with that. We will undoubtedly go back to some in-person hearings, but for a great many hearings, Zoom will remain the manner. We have crossed the Rubicon in that respect. And particularly for hearings that are only going to be a few hours in length, or for hearings which involve counsel all across the country, this is a way of proceeding efficiently without requiring parties to travel for short periods of time or long distances. We have also gone entirely to electronic documentation. We do require paper filings, but that's just for the record. All documentation must be uploaded to the Case Lines application, which we use, and all hearings proceed entirely on the basis of access by counsel and the judge to that electronic documentation. So in terms of deciding shareholder and corporate disputes, there are two routes in Canada. The first would be adjudication in our court, and the second would be private arbitration before an arbitrator or a panel of three selected by the parties. What are the decisions that go into, or the factors that go into the decision which route to go? Well, they're the following in general terms. First of all, in our courts, while we are prepared to seal some commercially sensitive information or not refer to it in open court, we do have the open court principle. All courts are available to the public, and all decisions, of course, are public. Arbitrations are typically, by agreement of the parties, entirely confidential. We have very clear rules of procedure and rights of appeal in the courts. The procedures are relatively clear in arbitration, but the rights of appeal are very narrow, and that can become a significant issue. The courts, of course, are open to all at essentially no cost. The only cost would be that you bear as a party would be your counsel cost, whereas arbitration tends to be quite expensive. You have to pay not just for the panel, but also for the proceedings. And as a result, these cases tend to be the larger cases. We even see a certain number of cases that proceed through our court and then finally get determined for various reasons in arbitration. The last matter I want to deal with is mediation, which I'll deal with very quickly. I mentioned that judges, the case management judge is very actively involved. We have mediation at two levels. The first would be formal. We have a requirement of mediation in an attempt to resolve matters consensually before any trial can be heard. But we also are encouraged as judges to have the parties attempt along the way in a more informal way to resolve their issues. And so for example, meetings with counsel, if it appears appropriate to the judge can require that there be discussion about settlement at that point or shortly thereafter or whatever. And the longer you're involved as a case management judge, obviously, the better you understand not just the issues and the merits on both sides, but the dynamics between the parties. And so increasingly as a case management judge, as you work through a case, you become involved in attempting to resolve the issue, either particular procedural matters or the larger issue in its entirety on a consensual basis. And from time to time, we will be asked to mediate such matters. We take that role on quite willingly and increasingly with some success. As a general rule, we find that while lawyers want to argue cases, clients simply want the matter resolved as quickly as possible. So I'm going to conclude by saying, on balance, while adjudication remains the traditional role of the courts in the area of corporate disputes, I would say that more and more we've come to appreciate that informal involvement and mediation has become as important a role for the judiciary. So thank you for your attention. I apologize for the technical problems earlier on. I hope that is of some interest to your court.
Ми дякуємо Герману Вільтозігелю.
We want to thank Mr. Wilton Ziegel
We
for the
thank
information
Herr
you've
Ziegel for the
provided.
information.
And we proceed to the next issue. New approaches to protection of the rights of the founders of stock companies. I'm giving the floor to Alexander Garnovich, Doctor of Law, Professor of the Commercial Process and Commercial Law, Institute of Law, Kyiv National University. Good afternoon, colleagues. My approach would be about new approaches to protecting the rights of the founders of the stock companies within the context of the active reform processes that are taking place. Somebody said we cannot hear the speaker. We can, in fact. Can you hear me now? Yes, we can hear you. Please continue. So within the context of the taking place in the area of corporate relations, there is a need to review the approaches to protecting the rights of the founders of the stock companies. The basis for it is the fact that at the stage of founding stock companies, abuse is possible, that in the future would touch upon the interests of the founders and could lead to financial losses or to the failure to reach the objectives of the founders, namely the reasons for which the company was established. In the process of founding a company and creating a new commercial organization, it's one of the elements of this legal consequences is the fact of the state registration of the stock company. As of the moment when it is registered, the legal literature says that this is the moment where a new person of law appears and emerges. It's well known that a stock company requires the right of the legal person as of the date of its registration, and the legislator says that this is only the 9th stage of the procedure of establishment, that is before the legal entity emerges. There are 8 different stages before that, and those stages, different relations develop, and the relations that develop before the state registration require protection of the rights and interests of the persons who participate in the founding and the establishment of the company. In order to clarify which remedies and ways to protect their rights can there be, one needs to identify the nature of the relations that emerge in the establishment of a company. Therefore, the relations that emerge related to the establishment of a stock company before they're registered are characterized by a special composition, and the main participants of such relations are the founders. After a company is established, its founders acquire the status of shareholders and participants, and therefore there are now relations of participation and other corporate relations. One should also pay attention to the fact that a stock company established in the process of reorganization does not have founders, because the way of establishing it is not related to the process of establishing a new legal entity. And the participants of such companies since the very beginning do not have the status of founders, but they have the status of participants of a legal entity that is being reorganized. The actions of the founders of the stock companies are very important for the establishment of such a company as a commercial entity and having a legal personality. The founders, as they implement their rights, acquire or make the most important decisions for the company at that stage. At the stage of establishing a stock company, violation of the law can take place if persons who participate in the establishments are the ones who do not have the right to do it. Analysis of the legal status of the founders of the stock companies allows one to remove from the circle of the persons who have these rights certain categories of people, physical and legal persons. The relations between the founders and the process of establishing stock company are of complex legal nature, which should be studied by analyzing the character of such relations, because characteristic features of relations between the founders affect the establishment of a certain approach, legal approach, toward the protection of the rights of their participants. The founders of a stock company are the persons on whose initiative the company is established, and the current law is based on the fact that in order to establish a stock company, one needs to have an act of will that is expressed in a certain established form. And that means that the initiative to establish it leads to certain legal consequences on condition if it is expressed in a legislatively established format. The relations between the founders are also related to the acts of will because they are in fact based on the will of the founders, because they confirmed their will. And in order to provide protection to the rights and interests of the founders, the legislators have established a principle according to which the conditions on which a stock company is established are to be made by a decision of all the founders, unanimous decision. In other words, the legislator has established this mechanism through the confirmation of the will of all the participants who participate in the establishment of a stock company. This approach of the legislative is rational, we believe, because no one can be forced to participate in a company where the conditions are unacceptable for that person. To protect the rights and interests of the founders in the process of establishing a stock company, one can also use the contractual mechanism to coordinate the will of the founders. So the founders can have an established or a statutory agreement which stipulates the actions to be taken in order to establish the stock company, although such a contract would identify the main characteristics of a company to be established. This contractual contract is not a round agreement. It would only be active before the company is registered. We believe that this instrument could be used with more effect if there is a pilot or a model agreement for certain types of stock companies. The next characteristic feature of those relations that affects certain approaches to protection of their rights is that the relations between the founders also have commercial nature. At the stage of establishment of a stock company, the founders are brought together by a common objective, namely the need to take certain preliminary actions to start a new commercial entity. Legally, what is joint for all of them is in fact that there is a legal obligation for all of those persons that they share common successes or failures, because not always that the founders would be able to finalize the procedure of establishing a new entity and get the benefits that they have planned for. The founders are not yet the shareholders, and they're not even the future shareholders, or at least their future role as shareholders are not related to their activities of the founders. About the economic nature of this type of relations, this is confirmed by their substantive content, material content, the factual behavior of the founders in terms of implementing their rights and duties of the founders, including to develop the property basis for that organization. And according to the law, every founder of a company should pay the full cost of the shares one buys before the date when the first issuance has been registered. This instrument for protecting the rights of the founders aims at preventing situations where some founders have invested their money while others have not made their contribution, have not paid for the shares, but they participate in decision-making related to the establishment of the company. A specific feature of the relation between the founders is the relative nature of such relations, because indirectly they are related to the relations of every founder with the other founders in the process of establishment of the company. And the list of the persons between whom such relations can develop in the process of establishment of a company can be seen in the decision to establish the company. So it's only between the persons who have made that decision to establish a stock company, but it's only between them who can have the shares in the process of establishment. Moreover, the shares that they buy cannot be alienated by the founders. Therefore, the participants of the relations between the founders of the company before it is registered, these can only be the persons who have made the decision to establish it, while for the other commercial entities, such relations are closed. For the relation between the founders, what is characteristic is the legal nature, and the legal meaning of the relations before the state registration is the subjective legal rights and duties of the founders of a company that are established in the law on stock companies, and the law talks about the rights of the founders to have the founding agreement, to vote at the meetings, to refuse to participate in the statutory meetings. In parallel with the rights, the founders are also vested with certain duties. So therefore, improper implementation by the founders of the duties vested in them by the legislators can lead to, first of all, qualification of the founders' behavior as a refusal to establish the stock company, which is the reason why, for the grounds for giving their contributions back to them. It can also lead to adoption by the National Securities Commission of a decision to deny registration of the report on the results of private issuing, which is the reason why the regulator can turn to the court demanding that the stock company be liquidated. A third possible consequence is the denial of the registration, and the fourth possible consequence of the failure to perform their duties is to decide that the stock company is fictitious, which is the ground for suing, for claiming that the stock company's activities should be terminated. The legal nature of the relations between the founders before the state registration can become more concrete in case of a special law, if the companies are planned to have some exceptional activities. While analyzing the approaches to protecting the rights of the founders, it is important to find out the place of those relations between the founders before the state registration within the system of legal relations. The special literature has different opinions by the experts. While solving this problem, we would tend to support our national legislators and the researchers who say that the relations between the founders of the stock company before it is registered are of commercial nature. The legal literature has repeatedly expressed an opinion that a type of commercial relations is corporate relations. Therefore, corporate relations have their clear boundaries in the general manner, and the moment when they emerge is the moment when this commercial entity is registered, and its termination means that it is done at the time when the activities are terminated. So the legal literature is dominated by the thought that the relations that develop before the state registration are not corporate relations, and their participants are not participants of corporate law or corporate relations. Such an approach to identifying the time when corporate relations emerge is based on the idea that before a commercial entity appears, it is impossible to have corporate relations, that only develop, change, and end up in terms of corporate rights that are related to certain commercial activities. We believe that the use of the rule on the impossibility to have corporate relations before the state registration of a commercial company in terms of a stock company is incorrect. We can explain our position. First of all, according to Article 167 of the Commercial Code, when we talk about corporate relations, we mean relations that emerge, change, or end in terms of corporate rights. And this legal definition, the notion of corporate relations, focus not so much on the commercial entity about which a person can have corporate rights, but specific corporate rights, rather, about where such relations can emerge or end or change. This approach is confirmed by the case law of the cases related to corporate relations with participation of the founders. If before the state registration of a stock company, there is a conflict between the founders about the rights that should be implemented, confirmed by their shares, it is believed that such a conflict in fact emerges from corporate relations. At the same time, the notion of corporate rights is also defined in the law on stock companies. The law says that a founder has all the rights that are confirmed by the shares except for the rights to alienate them. In other words, a stock company does not yet exist, while the founder already has corporate rights. And that means that a founder who in the process of establishing a stock company has purchased shares in the process of their private issuance, even before the state register, is a bearer of corporate rights, which is confirmed by the shares, except for the right to alienate them with obligations, such securities with certain obligations. So those relations that emerge before a stock company is established, the relation between the founders in terms of development, registration changes, or termination of the corporate rights are confirmed by the shares of the company can, according to the commercial code, be considered as corporate ones. This analysis of the nature of relations between the founders before the company is registered allows one in the future to talk about the need to expand the legal definition of corporate relations that can be found in Article 167 of the Commercial Code. Because of that, it is especially relevant to think about the jurisdiction of the conflicts that can emerge between the founders if the company has not been established, because usually corporate conflicts can be heard at the place where the stock company is located, and if the company has not been established, then the problem emerges with the territorial jurisdiction. We believe that while deciding upon the jurisdiction of the conflict between the founders of a stock company that has not been established, one can have a provision in the commercial code about exclusive jurisdiction for such conflicts. For example, the conflicts that can emerge from corporate relation between the founders of a stock company that has not yet been registered should be heard by commercial courts at the place where the founders have met. They have their Congress where they have decided to establish the company. And if it is impossible to identify the location, then the conflict between the founders shall be heard by a commercial court of Kyiv city. Thank you for attention. I would be ready to answer your questions. Thank you for this very important subject. It's a very interesting subject. I'm now giving the floor to Volodymyr Tsikalo, professor of the civil law and process at the legal department, Lviv National University.
Dear Volodymyr Ivanovich, dear judges of commercial courts, dear other colleagues that work in commercial courts, I welcome all participants of the roundtable, our guests of the conference. Allow me, on behalf of the Lviv Civil Law School, to welcome you at this forum Congratulations on the 30th anniversary of Foundation of Commercial Courts. Wish you success in all spheres of your activity, and I wish commercial judges to judge commercial cases successfully, endlessly. I want to start my presentation saying that on behalf of other parties, other legal entities mentioned today, corporate rights have one very important specific feature. They are defined by the size of share in statutory capital. If you take shareholders, their rights are conditioned by percentage of their shares, number of shares in statutory capital that belongs to shareholder or participants. Corporate rights are judged in relation with their percentage of their share. The recent case law of commercial courts and the Supreme Courts allow us to define two types of correlation with the number or percentage of shares. This correlation with number of shares that belong to a particular shareholder, for instance, shareholder who has the preferential right to buy shares, they can pretend to have such number of new shares that is in correlation with the current amount of shares. It is a proportional principle, but there is other correlation. Correlation with the number of shares established by law, not which belongs to a particular shareholder, but which is required by law. 5, 10, 95% or other. For instance, a shareholder that has 5% of common shares has the right to include his or her proposal into agenda. There are two types of correlation between number of shares that allows us to define particular criterion that could be defined into corporate rights and comparable rights. Proportional corporate rights include right for dividends, preferential right, right to vote, right to buy out shares, and comparable corporation rights. The right for audit, right to get information, right for mandatory sale of shares in case of buying dominating package of shares. There are two types of corporate rights, proportional and comparable, but they have one common feature. They depend on size of your share in statutory capital, but these rights are very different. Proportional rights belong to all shareholders, irrespective of the size of the share, 1% or 100%, while comparable rights belong only to those shareholders who have a certain share defined by law, not less, not more, 5, 10, 95 or more percent. So corporate rights are defined by statute of the company itself. So a person is a subject of proportionate corporate rights, but comparable rights could be acquired by a person only if the law defines a certain number. Article 78 of the law on shareholding companies says that every shareholder gets the access to information that is kept in the company. But a shareholder that owns a considerable package, 5% and more, has access to any information. about financial or commercial activity of the company. The second type, corporate rights, always depend on the will of other person, the will of the company or other shareholders. Subject of corporate law can exercise it, provided that other person fulfills his or her obligations and makes a particular action. Right to get dividends can be exercised, provided that the company makes the payment of dividends, while the comparable corporate rights include such rights that could be exercised by a shareholder, irrespective of the will of the company or other shareholders. For instance, if we talk about the forceful sale to the owner of dominating package, he is exercising his rights for forceful sale using escrow account. He recalculates and transfers value of shares to the account of other shareholders, and central depository transfers this to the account of dominating owner. This right of a shareholder having dominating package of shares that others sell him his shares does not depend on the will of other shareholders. This peculiarity is reflecting, is impacting protection of such comparable, commensurate corporate rights. Corporate rights could be exercised upon your own will, irrespective of will of other persons. That impacts the peculiarity of the protection of the right. To protect proportional corporate rights, it's enough to have general conditions provided for by Article 15 of Civil Code. Proportional corporate rights could be protected in case they are violated, they could be complained against. But there should be one more condition for protection of comparable, commensurate corporate rights. It's impossible to make it on your own will. And I shall give you the case laws illustrating 4 commensurate rights. Right to call general meeting of shareholders on your own, right for audit, right to information, a right for forceful sale out of shares. As regards the right to call extraordinary shareholders meeting, the law on shareholding company says that those shareholders who have 10% or more of the shares can require calling extraordinary general meeting. It is comparable right, it is commensurate right, because it belongs only to those who have 10% of shares or more. The law provides only for one way of protection, but other remedies were developed by court practice. The law says that such a shareholder can apply to supervisory board asking to call extraordinary shareholders meeting. And in case the board refuses to call the meeting, such a decision could be appealed to. But we understand that appealing against this decision is not the effective way of protection. The effective remedy is ruling that such decision of the board is unlawful. But what legislators suggest to us is an effective remedy. I believe that the law should not contain ineffective remedies. All remedies included in law must be effective. But in this particular case, in my opinion, a legislator chose ineffective method of protecting the rights. Recognizing the decision of the board, refusing to call a general meeting, null and void. When you recognize that their decision is null and void, is not effective, there is no result. They're not called. This method of protection, in my view, is ineffective. And in judicial practice, another remedy was invented. Invoking to call extraordinary general meeting or forcing to call mandatory meeting of shareholders. I want to draw your attention that such type of litigations, and this opinion is supported by Supreme Court. When the court refuse such appeal, shareholders who have 10% or more common shares, the court rejects it on the basis that they themselves have the right to call for extraordinary shareholders meeting. There is no need to ask the board of the company to do it. There is a possibility for them to call extraordinary shareholders meeting on their own will. I want to draw attention to other peculiarity. It was found in judicial practice. One should separate regular annual shareholders meeting and extraordinary shareholders meeting. In one of the cases considered by Supreme Court, they rejected the application of a person who had 51% of shares in the statutory capital. The court and the rejection of Supreme Court was based on the fact that such a person having 51% of shares could call extraordinary meeting himself. Yeah, I want to draw attention that such shareholders having more than 10%, they can call only extraordinary general meeting, but they cannot call annual meetings or regular meetings of shareholders. It's only the company itself who can call annual regular meeting. And they do it according to the law, not upon request of shareholders. When reviewing such disputes, they should differentiate between a regular annual meeting of shareholders and extraordinary meetings of shareholders. In such cases, when court reviews such categories of cases, these disputes should be differentiated. Next right to conduct an audit. Here I want to draw your attention to the fact that the right to conduct audit as a commensurate and comparable right includes such a possibility. A shareholder having more than 50% of shares has the right to select a shareholder who has 10% of shares can select an auditor on his own and conclude an agreement with the audit company. And second right, he can request the company to provide documents necessary for conducting audit. This right should be separated. First, the right to choose an auditor. Shareholder does it on his own will, irrespective of the will of the company. Second right, to get necessary documents for conducting audit. Here, shareholder depends on the will of the shareholding company. And I must say the consideration of such types of case invoking conducting an audit, the court should reject such an application because a shareholder who has more than 10% of shares has possibility to call an audit himself and conclude agreement with audit company. This right could be exercised on his own will, irrespective of the will of the company, while disputes regarding the duty to provide documents for audit depends on the will of the company. And judicial practice shows that such types of cases are reduced to establishing factual circumstances, whether he applied for that or not. And Supreme Court found that shareholder requested the company to provide the document several times, but he didn't receive the documents. And the answer was because term of preservation of these documents has ended. So this comparable right to conduct an audit does not depend on the will of the company. It doesn't depend on the reasonability of conducting an audit. And Supreme Court, in its resolutions, several times emphasized that, in my opinion, that could mean that an applicant in such cases could be an auditor and audit company. After agreement is concluded with audit companies, this duty to ask for documents comes from a shareholder to an audit company. The law of Ukraine on shareholding company doesn't provide for responsibility of the company or its officials for non-provision documents for audit. But Article 7 of the law of Ukraine on audit and financial statement and audit activity says clearly that a company is responsible to the auditor for completeness and reliability of data and documents provided for audit. So when there is a case on protection of the rights to audit, an audit or auditor's company could be an applicant. I want to emphasize one more thing. How corporate rights are exercised. Exercise of corporate rights, so they could be timely or timeless. So this is a timeless right. And one of the cases reviewed by Supreme Court rejected an application asking document for audit for the previous period. In particular, the person became a shareholder in 2019, but asked to provide documents for the audit starting from 2016. And application was rejected because that person got the right of a shareholding in 2019. So shareholding rights start from 2019, and his rights for previous periods could not be violated. This right conducting audit is timeless, is indefinite. It could be protected even in the previous periods. I shall give you a simple example. We all know that annual general meeting of shareholders must be held not before end of April. General meetings could make a decision to pay dividends. Imagine person became a shareholder on 20th of April, 10 days before annual meeting. Dividends are paid for the previous financial year. If we based our judgment that that person should be given documents only since the moment when the person became the shareholder, that person could not get access to the document for the previous period, previous part of that financial year. Requirements to provide documents should be meant for the previous periods of time as well. As regards the right to conduct an audit, the right to get information. In judicial practice, we have already certain remedies, in particular invoking provision of information. But interesting in the position of the courts regarding relation between right to get information and the right to govern the company. Chamber of Supreme Court supported the position of lower level court about invalidation of general meeting decision because shareholders were not provided information about calling the general election. Person was not informed that general meeting is convoked. And abstention of this decision was right to get information is an element of governance of the company, since the person was not informed about general meeting. So there is violation of right for governance. Cassation Commercial Court, in similar case, came to opposite decision. The person was not provided the document that should be provided to that person to get prepared for consideration of the issues on the agenda. Article 36 of the Ron Shareholding Company. Supreme Court ruled that this document, this information, is not a part to right for governance. It's a separate information. Since it is not a part of a right to governance, there are no grounds to recognize decision of general meeting invalid. I will not express my position regarding these decisions. I will only express my opinion, neither in first case nor in the second case. These informational powers, information rights, were not included into the right of information. They were only elements. They were only parts of right for governance. And the other right for forceful sale. I want to draw attention to the fact that in the literature and in the practice, for some reason, one believes that this right of the dominating shareholders who has 95 and more % of shares correspond to the right of other shareholders for the forceful purchase out, sell out of the rights. In my opinion, these rights are not corresponding to one another. On the contrary, they exclude one another. Article 65-3, Part 9 says directly, if the owner of dominating package of shares starts realizing his comparable right for forceful sell out of shares by other shareholders, then right of other shareholders for buying out of their shares is not applied. What does it mean? That means the sell-out procedure must not violate right of other shareholders for forceful purchase out. They can only raise the question that procedure for forceful sell-out is not abided by. Grand Chamber, in decisions concluded that, in fact, commercial courts are deprived of the right to exercise judicial control over this procedure. In my opinion, in this particular case, this is one of the few cases, only the only one, when the court exercises control over exercise of this or that right, establishing a fair price. The only type of disputes that arises as regards this right, these are disputes regarding establishing a fair price. Other shareholders are complaining against the price established by the owner of dominating package of shares. And when the court is reviewing such category of cases, he does not protect rights of other shareholders. It's not applied according to the law. He's exercising control of the procedure of the realization of the right of the dominating shareholders owner. In conclusion, I want once again draw your attention to the fact that comparable corporate rights could be exercised at their own will, irrespective of the will of other persons, will of the company or other shareholders. And that means that if there is such a possibility, then there is no need to give judicial protection to such rights. Thank you for your attention. Thank you for your interesting presentation and for agreeing to speak at our roundtable. keeping balance of interest between the owners and implementation of the squeeze-out procedure. I invite Yulia Tamanova, Doctor of Science, arbitrator of International Commercial Court at Ukrainian Chamber of Commerce.
Dear colleagues, good afternoon. Thank you for giving me a chance to speak. And I want to greet everyone on the occasion of this anniversary, where a lot of experience has been accumulated and becomes even more interesting to work. And of course, the society hopes that their rights and interests would be protected even better. The subject of my presentation today, but tell me, can you see my presentation that I'm sharing now? Thank you. As this is quite an unusual way of communication, I still decided to use my presentation to focus on certain issues. In fact, why the balance of interests? This issue has some history for me. Almost 3 years ago, when the squeeze-out procedure started to be implemented, a similar subject I decided to speak about at the legal event with the purpose to foresee, in fact, how the process would develop in terms of protection of the interests and striking this balance with the new squeeze-out procedure. It was new at that time. And some conclusions were made related to whether it is possible, and if there is one, how it is possible to strike this balance between the rights of the shareholders and where this protection of this balance would take place. And this is the first presentation page that I had, where I had the definition of the interests of the majority and minority shareholders. We understand that there are some legitimate official interests of the majority holders, such as increasing the quality of corporate management, reducing administrative costs, and of course, especially countering to find a balance as to how to counter those minority shareholders that create obstacles for effective management, in fact, the so-called dormant shareholders. But the practice throughout these years has shown that quite often the interests of majority holders are not only limited to those interests, but they're also related to their wish to have full control of the company by removing those minority holders who interfere with them, who are in the way of the policy that they want to pursue. Of course, the interest of the minority shareholders, on the other hand, as without their consent, without their wish, without their decisions, they're in fact stripped of their property, of their shares, so they either want to get the fair market price for them, or if they cannot get it, then they want to get their shares back and to remain owners of the stock. When the law was adopted, one of the main objectives of the law was to implement the main provisions of the EU directive on mergers. And at that time, we analyzed to see whether the law was compatible with the directive approaches or steps away from it. And in fact, we saw that it really deviates quite significantly, primarily because there is no preliminary mechanism to provide the right balance between the interests of the majority and minority shareholders before the squeeze-out procedure is applied. However, the EU directive contains some very important principal provisions that provide this vector for the application of the law. The directive, in fact, notes that the owners who have the minimum stock and who are stripped of it as a result of the squeezed-out procedure, they should get the proper protection of their rights equal to the protection of the rights of the majority shareholders, and that there should be the same approach and treatment of them regardless of the amount of their block. And of course, they should have certain possibility to get information on the eve of what is going to happen to them as a result of the squeeze out, what kind of compensation they would get as a result of their shares being taken away. At that time, we identified several problems in the procedure. The absence of administrative oversight. As soon as the dominating shareholder sends a notice to the company saying that he wants to buy out the shares from minority shareholders, since that time, the procedure in fact starts. It's like a house of cards. Nothing stops that procedure and prevents it from being started and to end up without a problem. There is not a single mechanism to stop it, to terminate it, or to have some additional checks of the actions of the company or of the majority shareholder that could lead to the squeeze out. At the same time, when the law was adopted, and even today, the absence of a standard valuation or evaluation of the shares to be bought out, which could prevent the application of unfair valuation. The absence of control of the evaluation quality or the mandatory review of the reports by professional associations. The State Property Fund has repeatedly tried to initiate introduction of some mechanisms of control of evaluation with the review of the reports. But even today, that in fact remains, for the majority shareholders to decide whether they want to have their reports evaluated. And the key problem to protect the interests of the minority shareholders, to protect them, is in fact the impossibility to get any documents of the company to understand what the real price of the buyout can be adopted, what chances they have to challenge it, whether they can understand the effect of the squeeze-out procedure for themselves. At the same time, as they initiate as they can sue for protection of their rights, they in fact carry the financial burden, because on the one hand, they're stripped of their property rights, and on the other hand, they even have an additional financial burden to have their rights protected. What do we have today? That's what I said 3 years ago, in fact. In fact, these same problems have now been confirmed, not only in the squeeze-out procedure, but during the the trials. And now I want to proceed to what we have today and what we can do, even without changing the law. The most important thing that all the market participants have been waiting for was the decision of the Grand Chamber in case number 908-137-18, the Tech Power Parade, that in fact, for the first time, was to decide the issue of how the court should approach cases on squeeze-out. And it's very important that the Grand Chamber recognized the principal possibility of unfair behavior on the one hand of the majority shareholder when the cost of the share is adopted for buyout. On the other hand, it confirmed that the position of the minority shareholders were weak, who have to challenge the buyout price post factum, having too little information for their own evaluation or to challenge the evaluation that has been commissioned by the company. And the Grand Chamber spoke about the key criteria to assess the legitimacy of the squeeze out, whether it complied with the legitimate procedure, whether the objective was legitimate, and whether the minority shareholders were proposed a fair price of these shares. This latter criteria is the decisive one to understand whether the balance of interests was violated. At the same time, I'd like to draw your attention to such a criterion where it is presumed that it always exists in the squeeze-out procedure. That is the legitimate objective or purpose. And here we should get back to the very first slide where we spoke about the objective of the majority and minority shareholders, the purpose, and the objective of the majority shareholders is to increase the quality of corporate management. And it is presumed that this objective is legitimate, is always legitimate, that it meets the interests of the society. At the same time, we understand that if the Supreme Court has pointed to the fact that the legitimate purpose is a criteria to evaluate the legitimate nature of a squeeze-out, then there can be situations or conflicts where one would try to prove that the majority shareholder had a different objective for the squeeze-out procedure, namely to get, for example, full control of the company, which would not affect, which would not improve the corporate management quality level, but at a much lower price. So in spite of the fact that the legitimate purpose is presumed, however, I would allow myself to say that in the future, this issue can be brought up about whether the squeeze-out procedure was conducted with a legitimate aim. Next. What has happened throughout those 3 years? Well, of course, the minority shareholders who have been stripped of their shares as a result of the squeeze-out, they try to look for the ways for the remedies. And I have identified the main categories of such remedies that have been applied by the minority shareholders in different cases that are now pending at different stages. First of all, that's deciding that the decision of the supervisory board on the cost of a share was nullified, that the public requirement was nullified, the recovery of the fair cost of the actions, damages recovery, the need to transfer the shares from the depository account to the minority shareholders' personal accounts, recognizing the right to get compensation for the squeezed out shares, recognition of that the company does not have the right for a squeeze out, and since the very beginning, the minority shareholders have faced active resistance in terms of the use of different remedies. Quite often, one could hear statements that the means that have been applied are ineffective, or the ones that cannot be applied because they are not foreseen in the law. And the very first problem that the minority shareholders faced was the definition of the remedy as such. Identification of the remedy, how to have their rights protected as a result of squeeze out. What is interesting in this point of view is to get back again to the case that was heard by the Grand Chamber and to its decision, because in the text, in fact, it said about 2 different types of remedies, either claiming damages in the amount of the difference between the established share price and the fair price, or to make sure that that deed was unfair and should be nullified, should be voided. Although, if we look at the text of the judgment of the Grand Chamber, they spoke as a deed not about this public requirement, but the very squeeze-out procedure, which I believe is also an issue to be resolved by the courts with this case law. What should be voided? Either this public requirement as a one-sided unilateral deed that has its consequences, or the squeeze-out procedure, as it says now. And of course, what is interesting is a separate position, dissenting or separate opinion about that resolution, which was about the remedies. Because other ideas were suggested about possible remedies or possible ways. Either a deed is null and void because it violates the public order if a procedure has been violated, or other ways, other remedies should be applied, in particular the recovery of the property that has not been acquired legitimately if the shares have been transferred from the minority shareholders to the majority shareholders' accounts. But these are my considerations about proper remedies in such a category of cases. I believe that, in fact, we should only look at two different ways: either making sure that a deed is null and void, or to pay the difference between the price of the shares that have been bought out and the fair price. And there can be different violations of the rights of the minority shareholders, as a result of which such remedies can be applied. Nullifying a deed, I believe, should take place only in one situation: to comply with the balance of interests, because it's not only the interests of the minority shareholders that may require protection, but the interests of the majority holders as well, in a situation where it turns out that at the moment when the squeeze-out procedure was conducted, the majority shareholders, individually or together with the other persons, did not have 95% of the stock. In other words, they did not even have the right to conduct the squeeze-out, and that would be the basic principle, the basic ground to consider this deed null and void. Other violations that take place during the squeeze-out procedure, I believe, to protect the interests of the minority shareholders, should be about paying the difference between the prices of the shares. These can be violations in the course of the squeeze-out procedure, and we have already seen such situations in the courts. The minority shareholders would point to that when they, for example, they would not get the copies of the decisions, and that's why they would claim that they had not been informed about the procedure, or serious violations during the establishment of the price of a share during the buyout procedure. Now, I think that quite soon the courts would face a problem, an important problem, about whether the situation is legitimate when, for example, the share prices were evaluated in a minority block. I think it's of principal nature. In order to have the equal treatment of all the shareholders and to identify the fair price of the shares, one needs to identify the price of the shares only in a 100% block. One cannot decide what the price of it would be with a minority block with a certain discount because of of lower liquidity, because that would lead to lowered price of the shares because of the evaluation procedure. A separate issue, which I believe should be focused on, is adoption of the price of the shares by the supervisory board. As we understand, in most cases, the supervisory board has quite a formal approach to adopting the results of the evaluation as it gets the reports from the evaluators. And as we understand that the composition of the supervisory board is affected by the majority shareholders, then the supervisory board would adopt the reports on the price, the value of a share in a formal way, meeting most often the interests of the majority holder. Especially at the beginning, we heard the position of many judges who said that one needs to challenge the decisions of the supervisory board in order to have the right to recover the difference between the value of the buyout price and the fair price. But that's quite controversial because on the one hand, one needs to assess the decisions of the supervisory board not only in a formal way, but the supervisory board should be based on the interests of all the shareholders, not only of the dominating ones. That's why the supervisory board, even without having special knowledge, but having proper information about financial indicators of the work of the company for several preceding years and the audit reports, they can in fact see whether the price of the share that was provided in the reports of the evaluators was fair. And if they see that the price indicated by the evaluator does not meet and cannot really compare with the financial results of the company's work, company's performance, I believe that the decision of the supervisory board can then be considered unlawful. At the same time, whether it needs to be recognized as unlawful, I don't think this is extremely necessary because the remedy such is recovering the difference between the established price and the fair price of the shares. And in order to recover it, it would be futile to make sure that a necessary remedy for the minority shareholders is to challenge the decisions of the supervisory board. At the same time, there are some other remedies that I believe should not be applied. This is recognition, for example, of the decisions of the supervisory board as unlawful. For example, like a ban on alienation of the shares. This is rather about the protection and ensuring, securing, but as the squeeze out is quite a quick procedure, it would not be rational. But the courts have not yet decided because of proportionality and because they need to find the balance between the interests of the majority and minority shareholders to use such security means in this type of conflicts. And to get the shares back to the minority shareholders is also quite controversial because if the deed is recognized as null and void, then even the consequences of these deed would be null and void as well. And the recognition of the right to get compensation. As the minority shareholders, as it was said at the beginning, have to pay quite serious court fees if they sue, if they submit property claims on compensation. In order to minimize the financial burden, they have rather submitted claims suggesting that the decision should be considered null and void. Thank you. I'm about to finish. So the issue about the fair price of the shares and what remedies should be applied. Compensation, which is the one that is used en masse now, even at the decisions of the Green Chamber, as losses, but then it causes certain problems of proving, especially proving the guilt. If we base on the presumption of guilt when saying that the buyout price was unfair, then we have to presume that presumes a guilt there. And the third is a possibility to recover the financial obligations that have not been properly met. As regards the weak sides of the squeeze-out procedure, I won't talk about that. And this is the last slide, suggesting some ideas that I believe can increase the level of protection of the minority shareholders. First of all, the courts, as the minority shareholders submit their claims, they have to prove that the price was not fair. And the courts would often demand that the minority shareholder would submit their own evaluation or a review of the evaluation conducted by the companies in order to adopt the price of a buyout share. However, such reports quite often cannot be provided by the minority shareholders because they do not have access to all the information. That's why even if they do submit it, it would be quite easy to challenge it while reviewing it. Next, of course, one should demand from the company that they provide a full report about the report of the evaluators with all the additional documents and paying special attention not only to the financial indicators, but also to the property, the assets, the products that were produced, the investment plans. Quite often, this is not taken into account by the courts, although this would affect a possibility to identify a fair price. What is also necessary, I believe, is to have expert evaluation in this category of cases, forensic expert evaluation. It should be comprehensive, and in fact, it should decide upon two things. Please finish. 2 more sentences. Whether the report was conducted in compliance with the legal requirements for evaluation of the property, and if not, then what was the market value of one share at a certain point in time. However, if one used the property minimum and the comparative approach, one should have to have a comprehensive expert assessment. And the last thing, one needs to analyze the behavior of the supervisory board from the point of view of its active obligation to check, to inspect the report of the evaluator and to compare it with the financial indicators of the company. And probably not only for the previous year, but at least for the 3 to 5 previous years, because before the squeeze-out procedure, the buyout procedure, the majority shareholder could carry out certain actions that could lead to reduction of the price, to lowered price of the share, and a possibility to decide the price of the buyout shares. I understand that these are some ideas for the future. And now let's see how these cases would be heard and decided on what the decisions of the courts would be after this important decision of the Grand Chamber in the DTEC case, and whether the case law would change in terms of assessing the remedies and proving the fair price. Thank you. Thank you.
Статті 6 Європейської конвенції з прав людини щодо арбітражних...
Relevance of Article 6 European Code for Arbitration Procedure. The floor is given to Daniel Rittriker, Professor, Senior Lawyer, Register of European Court of Human Rights, please.
Dear judges, dear chairman, I hope you can hear me. In Ukraine, I'm very pleased to participate in this very important event, in this birthday of 30 years. I received the invitation to this important event only on a rather short notice, so please excuse the imperfect nature of my summary. A summary of an otherwise interesting and complex issue, that is the relevance of Article 6 of the European Convention on Human Rights for arbitration procedure. And please also excuse my terrible voice. It is still quite cold here in Strasbourg, so I got a cold. I can't change that. From the outset, arbitration and the European Convention of Human Rights are strange bedfellows. Arbitration has many advantages that are not identical with the court or the convention's concerns and activities. Speediness, flexibility, contractual freedom, confidential nature, private actors, private courts. And the principle the court elaborated is quite clear. Article 6 does not preclude the setting of an arbitration tribunal in order to settle certain disputes, especially since arbitration clauses have undeniable advantages for the individual concerned as well as for the administration of justice. They do in principle not offend against the convention. The statistics are quite clear also. Most of the cases involving commercial arbitration, among them, only very few led to violations of the convention, European Convention of Human Rights. For instance, the case of Studa versus the Czech Republic. I provided organizers of the event with a list of cases. I don't know whether it was made available to the audience as well. But there is nevertheless a bunch of cases imposing some limits on the private actors when using arbitration, in particular in so-called compulsory arbitration. In particular, more recently, in sports arbitration, the court, our court, the Strasbourg court, has identified certain problems in the cases of Mutu, Pechstein, and Ali Riza. They might be very relevant for commercial arbitration. Therefore, I will also refer to them in my talk. A preliminary question first. The jurisdiction ratio persone of our courts to hear such cases. The problem is simple. How can a state party to the convention be held responsible for a violation of the convention committed by private arbitration tribunals? The court gave quite a clear answer, among others, in Mutu and Pechstein. Also, the Court of Arbitration for Sports, the CAS, which is based in Lausanne, in Switzerland, was neither a state court nor another institution of public law, but an entity set up under a private law foundation. The Swiss courts had jurisdiction to determine the validity of the decision issued by the CAS, and the Federal Supreme Court has dismissed applicants' appeals, thus attributing a res judicata effect to the arbitration awards in question. Therefore, the state party, Switzerland, bore responsibility, and the court had jurisdiction ratione persone. Then, a second point is the fundamental distinction to be made between voluntary and compulsory arbitration. A distinction has to be drawn between voluntary and compulsory arbitration. In case of compulsory arbitration, where arbitration is imposed by law, the parties have no opportunity to remove their dispute from the jurisdiction of the arbitration tribunal. Consequently, the arbitration tribunal must afford the guarantees set forth in Article 6. There are two situations where the court considers the arbitration as compulsory, even though it was not as such imposed by law. First of all, exactly in the sports arbitration cases. Arbitration clauses are generally considered as being imposed on athletes and players. There is basically no choice. There is no balance of power between the individual and the club's federations, contrary to companies in commercial arbitration. So either the athlete or the player wants to compete on an international level, and then he has to sign up to these clauses, or he has to renounce on his sport as a profession. For instance, in Mutu and Pechstein versus Switzerland, the refusal to accept arbitration clause would have entailed negative consequences for the second applicant's professional life, and therefore the court considered that the applicant had not accepted this clause freely and in a non-equivocal manner. Speed skater Pechstein from Germany. And second exception, where we would consider arbitration which is not imposed by law as a compulsory. Arbitration may be neither compulsory nor voluntary, but imposed on the applicant by third parties. In the case of Studa versus the Czech Republic. In this case, there was an agreement to submit to arbitration made between the company on one side, of which the applicant was a minority shareholder, or the main shareholder of that company. It was considered a compulsory arbitration because the applicant, minority shareholder, did not have a choice. In this case, the court found a violation of Article 6 because of lack of publicity of the debates. On the voluntary arbitration, on the other hand, in principle, it does not raise any issues under Article 6, paragraph 1, since it is entered into freely. However, when parties agree to arbitration, this does not automatically imply that they have waived all their rights under Article 6. The acceptance of an arbitration clause must be free, lawful, and unequivocal to be considered a waiver of all or some of the guarantees provided by Article 6, paragraph 1. The court spends then, in these cases, the main exam on this issue, if the consent was valid. For instance, in the cases of Taban and Eiffage contra Switzerland. Another question is whether all rights, all guarantees under Article 6 can be waived. Certainly, one can waive the right to a public hearing. What about the right to an independent and impartial judge or arbitrator? According to the case law, such a waiver seems to be possible. I'll come back when I talk about the Finnish case, which I quote in my list. But again, only if it was made free, lawful, and unequivocal. So, intermediate conclusion, Article 6 does not preclude the setting up of arbitration tribunals in order to settle certain disputes. Nevertheless, distinction has to be drawn between voluntary and compulsory arbitration. A further question is then, are the guarantees of Article 6, paragraph 1 applicable to arbitration proceedings or subsequent proceedings before ordinary courts? The point of departure is Article 6. Article 6 only applies to proceedings where the determination of civil rights and obligations or a criminal charge is at stake. It is, of course, only the civil limb of this article that might enter into play in our discussion. Interestingly, in commercial arbitration proceedings, the Strasbourg courts did usually not examine the question of applicability of Article 6 to arbitration proceedings separately from the question of voluntary or compulsory arbitration. In other words, where the rights were validly waived, the guarantees under Article 6 were not considered applicable. But where such a waiver was not unequivocal or in compulsory arbitration, like in the Suda case, those guarantees were applicable. But in some cases, the court held that the right to recover the sums awarded by the arbitration court is considered a civil right within the meaning of Article 6. Therefore, Article 6 is applicable to proceedings brought before ordinary courts to have the arbitration award set aside. Here, things are quite clear. In a more recent sport-related arbitration proceedings, the court examined separately the question of if whether Article 6 is applicable or not, and often in an affirmative way. For instance, the payment of damages to a football club concerns rights of a pecuniary nature and stems from a contractual relationship between private persons. Therefore, these rights in question are civil rights within the meaning of Article 6. It's the Mutu and Pechstein case, as well as the Ali Riza case, Ali Riza versus Turkey. Other case, the downgrade from top level to provincial referee has an adverse effect on the professional career as assistant referee, especially when this decision also resulted in the applicant losing part of his earnings. Therefore, the rights in question were also civil. Article 6 was also applicable. However, a suspension from any football-related activity for amateur football players does not concern rights of pecuniary nature, rendering Article 6, paragraph 1 inapplicable. This was said in the Ali Riza case. If you don't earn your livings with football, then Article 6 might not be applicable. But if you're a professional football player, then Article 6 is applicable. It's quite interesting, this distinction. Okay, so now I have set out the formalities, the admissibility issues. Now I want to see which kind of law guarantees of Article 6 are in fact relevant and applicable in these arbitration proceedings. Access to court is, of course, the most fundamental right under Article 6. The question of access to court is closely linked to the question of waiver of rights, and as a result of the distinction between voluntary and compulsory arbitration, which I outlined before. The right to access to court does not require a case to be submitted to ordinary courts, courts of law of the classic kind, integrated within the standard judicial machinery of the country. Instead, the word tribunal in Article 6 may comprise another body set up to determine a limited number of specific issues. These will be called in the case of Muton Pechstein or Ali Lisa versus Turkey. A person may waive their right to have their case heard by a court or tribunal by agreeing to an arbitration clause. I said this before. As I said in the introduction, an arbitration clause which has undeniable advantages for the individual concerned as well as for the administration of justice does not in principle offend against the convention. So one can renounce on access to an ordinary court. In this case, the court bases its main exam on the question whether a waiver was free, lawful, and unequivocal. As for instance, in the Taban versus Switzerland case, which is also on the list of cases. In this case, the applicant, a businessman from Tunisia, has contracted with a French society and chose the law of the state of New York as applicable law. The contract included an arbitration clause excluding all legal remedies before ordinary courts. I quote, "The decision of the arbitration shall be final and binding, and neither party shall have any right to appeal such decision to any court of law." Before the court, the applicant argued nevertheless that he did not have access to an ordinary state court and that his waiver was not valid. The court held that this clause was particularly clear and that, moreover, other procedural and institutional guarantees existed. In other words, there was no appearance of equivocal waiver of rights under Article 6. So the application was declared invisible by our court. So as a result, if somebody agreed freely, lawfully, and unequivocally on arbitration, he cannot validly claim afterwards a violation of not being heard by an ordinary court. Another aspect that falls under the access to court business is enforcement of arbitration decisions, and this is also interesting because we have some Ukrainian cases. The failure to enforce an arbitration decision may lead to a violation of Article 6. The failure to enforce an arbitration decision by state courts may lead to a violation of Article 6. And this was said in Ostapenko versus Ukraine or Regent Company versus Ukraine. Cases decided by the Strasbourg court. Another guarantee sometimes on the table in our case law is the guarantee of a tribunal established by law. This point has at least been discussed twice in arbitration cases in Strasbourg. In the Suda case, as of the Czech Republic, the court held quite shortly, quite briefly, that arbitration clause gave decision-making power to arbitrators on the list of a limited liability company that was not an arbitration tribunal established by law. But this is quite an exceptional case in the jurisprudence of the court. Issue of tribunal established by law was also considered in sports-related arbitration, but it was not seen as problematic. An arbitral tribunal will be considered a tribunal established by law within the meaning of Article 6 if it is satisfied certain criteria, as laid out in the Mutter and Pechstein case. For the Court of Arbitration for Sport, again, for the CAS in Lausanne. In this case, our court held that although the CAS derived its authority from a private law foundation, it enjoyed full jurisdiction in determining on the basis of rules of law and after proceedings conducted in a prescribed manner, all issues of fact and law submitted to it in the context of the disputes brought before it. There was no problem under this heading, tribunal established by law, but there was a concurring opinion by certain judges which question this issue. But for the majority, the things were quite clear for the CAS, the Court of Arbitration for Sport in Lausanne. Public hearing is another guarantee, which I briefly mentioned. Public hearing, prevalent principles under Article 6, paragraph 1, in this context apply to hearings before arbitration tribunals. So in principle, an applicant has the right of a public hearing unless there is a problem of public order or if the questions are very technical, which should be resolved better in writing. But the principle is to have at least one public hearing during the whole internal domestic proceeding. But Article 6 does not preclude a free either express or tacit waiver of the right to a public hearing. The right to a public hearing can be validly waived even in court proceedings. Therefore, the same applies to arbitration proceedings as well, which often a purpose is often to avoid publicity. Thus, the lack of a public hearing in arbitration does not of itself make the arbitration proceedings unreasonable, especially if the applicant chooses arbitration proceedings instead of proceedings before the ordinary civil courts, voluntary arbitration. In compulsory arbitration, of course, the court found violations of the right, this right to public hearing in the Pechstein, Mutu and the Suda case, because the applicants did not raise the right to public hearing, and they were not given the possibility of arguing their case in a public hearing. But this is again in the framework of compulsory arbitration. The last guarantee which I want to quickly mention, and then I finish with some conclusions in 5 minutes. The independence and impartiality of judges or arbitrators. The question is, of course, whether a right to independent and impartial judge or arbitrator can be validly waived in a voluntary arbitration, especially when applicants have reasons and the opportunity to challenge the independence and impartiality of the arbitrator, but do not pursue such a challenge. They are considered to have unequivocally waived the right to an impartial judge. This was said in the Suorvan Yemi and others versus Finland case, which is on my list. Conversely, when such a challenge is raised, the arbitration procedure has to provide the guarantees of Article 6, even in case of voluntary arbitration. In compulsory arbitration, it might be different. The applicant, here in the case, sports case, was not considered to have unequivocally waived his right to challenge the independence and impartiality of the tribunal in Mutu and Pechstein versus Switzerland case. But on the merits in this case, no violation of Article 6 for the following reasons were found, because neither was the CAS, the sports arbitration in Switzerland, to be considered as structurally dependent or financially dependent on the sports federations, nor did the two challenge arbitrators lack individual independence or impartiality. But at least in one case, the court found a problem in the Ali Risa case versus Turkey. There were strong and organizational ties between the board of directors and arbitration committee of the Turkish Football Federation, so that the structural deficits of the arbitration committee on account of the vast powers given to the board of directors over its organizational operation were a legitimate reason to doubt that the members of the arbitration committee act with the necessary independence and impartiality. And interestingly also, a last case which I'm going to mention, a case from the Swiss Federal Tribunal, this time not from the Strasbourg court. In a recent case, also on individual independence, on impartiality, judged by the Swiss Federal Tribunal in the judgment of the 22nd December of last year, concerning the Chinese swimmer Sun Yang. One of the case, the CAS, the Court of Arbitration for Sports arbitrators, was considered not being impartial by the Swiss Federal Tribunal because he made some problematic statements in his Twitter account against Chinese people in general, when he was the member of a panel charged to decide the case of this famous Chinese swimmer. And here, this is a short summary of the most important reasoning of the Swiss Federal Tribunal. In the case at hand, the arbitrator has taken up the cause of animal protection in the context of tweets. In principle, an arbitrator can also defend his convictions on social networks, but with the restraint required of judges. The choice of words and the repeated use of violent expressions is problematic in the specific case. In his tweets, the arbitrator castigates a Chinese practice of dog slaughter and denounces the consumption of this meat at a local festival in China. Some expressions refer to the skin color of certain Chinese people he targets. In addition, the arbitrator also made the sad remarks in tweets after his appointment as a president of the panel of arbitrators deciding in the Sun Yang case. In view of all relevant circumstances, the Federal Supreme Court therefore considered that the doubts as to the impartiality of the arbitrator were objectively justified. In other words, this is my own conclusion, appearances matter, or to recall an old saying, justice must not only be done, but also be seen to be done. Two conclusions or three conclusions. Article 6 of our Convention on Human Rights and our court, the Strasbourg Court, has become quite relevant in forced arbitration procedures, where this article is fully applicable. This is the inter alia due to its involvement, recent involvement in sports arbitration, in the Mutu, Pechstein, and Algeriza cases. On the other hand, it is less relevant so far in voluntary arbitration, in particular in commercial arbitration, where two equally, normally I would say, equally powerful companies meet. The court nevertheless plays an important role in determining whether certain waiver of rights has been validly made. Thank you very much for your kind attention.
Дякуємо Даніелю Рідікеру.
Thank you, Mr. Riedeker, for this very comprehensive presentation. And I would like to inform the participants of this roundtable that the agenda has been exhausted. Until recently, while preparing such roundtables, we have tried to have such events live, because live communication, cannot be replaced by anything else. Unfortunately, the quarantine has introduced its problems. We have had this event online. Well, it's better to have it online rather than nothing. At the same time, I'd like to tell you that in this event, we have had more than 100 participants, and we really like it. As a result of this event, we understand that I wanted to write it down, but I then managed to when I was listening to Inna Spasiba Fatieva. And I wanted to say that today we have had here judges and researchers. So we just have to communicate with one another, because many researchers are using our judgments in their studies. Some people have praised them today, others have criticized them. I think that's normal and natural. So I really want to thank everyone for having participated. At the moment, well, I see 84 participants, but we used to have more than 100 of them. So we want to thank everyone. And we hope that our meetings would be regular, not only online, but live as well. I want to especially thank the project of the Council of Europe for the support of Ukraine in the enforcement of the judgments within the context of the Article 6 of the European Convention on Human Rights, that is support of this event. Thank you very much, everybody, and goodbye.
Дякую. Дякую, до побачення.
Дякуємо.